It's just now.
All right, good afternoon, everyone. Welcome to the Judicial Proceedings Committee. Today is Wednesday, March 6th, 2024. We have 17 bills on the docket. We're going to start off with Senate Bills 939 and 940. We're going to take those two together with Senator King. I see you here. Welcome. Would you like to bring up your sponsor panel? All right, I can.
Thank you, Mr. Chairman, members of the committee. Drivers, pedestrians, cyclists, and workers are all being put in harm's way by the actions of drivers who operate their motor vehicles with blatant disregard for public safety, and our laws need to be strengthened to address this escalating issue. As a side note, as I was getting onto the ICC the other afternoon, there were some young men on their Suzukis racing very fast past me, and then I understand one of them lost his life in that race on Sunday afternoon. Senate Bills 939 and 940 will add and increase penalties, as well as expanding the list of violations that qualify as aggressive driving. Mr. Chair, I have on my panel with boots on the ground in combating this issue, so I am going to keep my testimony brief and defer to their expertise and experiences. But before I finish, I am introducing an amendment to each of these bills, which will add to their titles, the Sergeant Patrick Kemp Act. I will let Sergeant Kemp tell his story, but once you hear it, I am sure you will agree that this amendment is more than appropriate. And I ask for your favorable report on Senate Bills 939 and 940.
Good afternoon. My name is Sergeant Patrick Kemp of the Montgomery County Police Department. On October 18th, 2023, I was intentionally struck by a driver on northbound I-270 at Watkins Mill Road who was going well over 100 miles per hour. As a result of the crash, I lost my right leg on scene, and my left leg was amputated after I was flown to shock trauma in Baltimore. With 2 minutes or 3 minutes, I don't have the time to go into the full details of my story, but if you don't already know it, I encourage you to Google my incident to get a full grasp of the seriousness of the events leading up to the crash and my long road to recovery since. What is critical to these proposed acts are that the individual that I was trying to stop was a menace to the roadways of Montgomery County and Frederick counties. My history with the individual goes back many years, but to speak to 2023 alone, his actions, baiting the police, running red lights, skidding tires, speeding through intersections, speeding in general, and at most dangerously, driving at one point when I saw him in May 26, 2023, 136 miles per hour on I-270, a 55 mile per hour zone. Absent fleeing from the police, all of these driving actions, when brought to court, would be punishable by a maximum fine or maximum of points on a driving record and a $570 fine for that reckless driving violation as it's currently written. Most traffic violations in our state are and should remain exactly that, traffic. However, when it came time for me to file charges against the individual in my situation, there were truly no appropriate criminal charges that applied outside of potentially disorderly conduct. There's no doubt that turning off one's lights, going over 130 miles per hour, fleeing from the police, and baiting police rises to the level of serious criminal conduct that poses a serious danger to the life and safety of our community. I think of two other examples that apply to Bill 939, intersection takeovers and hit and runs, similar to the one that occurred in Pike and Rose in 2021 in Montgomery County. When those intersection takeovers occur and drivers spin around and have no regard for individuals, there may not be the intent to injure them, but as a result, if ones are injured, thankfully not happen in our state at this point, but we see in the news, those injuries are serious and there needs to be criminal charges that come with it. As it pertains to Bill 940, the repeated driving actions of not only the individual in my case, but many others in the state of Maryland show that our current traffic laws for negligent, reckless, and aggressive driving have no teeth. Drivers consistently show through their disregard, especially for speed, that minor fines and points on their license that are no consequence. The goal is not to put everyone in jail or cause community members not to be able to drive. However, those driving actions are regarded as normal in my professional experience as a traffic-centered officer, and that creates a substantial risk for the safety of the community members, not only in Montgomery County, but throughout our state. Briefly, two other incidents that I want to highlight for the traffic portion of these bills. Just 6 days before my crash on October 12th at 2:12 in the morning, I stopped a Chevrolet Camaro going 95 and a 55 on I-270. Previous stop, I had stopped that driver on January 16th going 91 and the 55. At 2:21, just 9 minutes later, I stopped a Lexus going 95 and the 55. On June 2nd of 23, I stopped him going 95 and the 55 in the same location. I want to thank Senator King for taking a stand against these extremely dangerous driving behaviors in light of my serious incident. I thank the committee for taking the time to allow me to share why these changes are so important, especially after my personal experiences, not only over my 10-year career, but especially in October of 2023. Thank you.
Good afternoon, Chair Smith and members of the Judicial Proceedings Committee. My name is Captain Warren Jensen, and I'm with the Montgomery County Police Department. I'm the Director of the Traffic Operations Division. I also want to thank Senator King for this important traffic safety bill that seeks to enhance penalties for transportation article sections. This legislation aims to improve roadway safety in our state. Currently, reckless endangerment cannot be charged criminally when a vehicle is involved. Officers are limited to citing reckless drivers, which is a pre-payable traffic offense. Sergeant Kep spoke at length about that. This simply isn't enough to deter the egregious driving behaviors or hold individuals accountable when they put others at risk on the roadway. Senate Bill 939 closes this gap by removing that exclusion, and it gives the police leeway to criminally charge those who operate a motor vehicle in extremely reckless ways. The stronger penalty sends a clear message. Reckless driving is not a minor violation. It's a crime with serious consequences. One brief story referenced this. When I was a patrol officer, I had a case where there was a neighbor dispute. Neighborhood school children, 12, 13 years old, had set up a basketball hoop at the edge of a roadway in Montgomery County. And every day they went out and played basketball after school. One of the neighbors didn't like this. So every day he would come by and he would swerve at the children. So I got called to the case on about I don't know why it took the parents, on about the third day I got called. And I went to investigate it, and I went and spoke to a commissioner. And to me, it seemed like reckless endangerment. He didn't intend to strike the children, but if he had hit a curb, lost control, or one of the kids had darted out, he likely would have killed them or seriously injured the children. That's when I learned about the vehicle exclusion, that just did not apply. And we ended up charging him with a traffic citation and sent him on his way that day. And I just felt like that was extremely dangerous. That's when I first learned about it. Montgomery County Police Department strongly supports this bill. The bill strengthens our current laws, provides stronger penalties. Our officers witnessed the devastating consequences, which I don't really need to touch on. I think Sergeant Kep's a great example of that. This bill empowers us with stronger measures to prevent these tragedies. This legislation has potential to reduce crashes, makes our roads safer. A major goal of the Montgomery County Police Department and our Vision Zero program is to build a culture of safety on our roadways that includes penalties for egregious driving behavior. I urge you to consider the safety of our communities and the critical role of law enforcement. Please support Senate Bill 939. And as far as Senate Bill 940, just a few points. Reckless, negligent, and aggressive driving that obviously go hand in hand with the previous bill. They continue to plague our communities. The existing traffic laws do provide some deterrent, but I think there's room for improvement, and I think this bill does just that. Increased fines and potential periods of incarceration will be aligned with the severity of the reckless and aggressive driving behaviors, hopefully leading to more safer roadways. I consider you to urge the safety of our communities, and thank you for considering these bills.
Good afternoon, Chair Smith, members of the committee. My name is Kyle O'Grady. I appear on behalf of State's Attorney John McCarthy in the Montgomery County State's Attorney's Office, where I serve as a prosecutor in the Felony Trial Division, and I'm the acting supervisor of the Traffic Fatality Unit. Just kind of addressing reckless endangerment and reckless driving. Setting aside the similarity in their names, these two offenses are not the same thing. First, the object of the disregard is different. Reckless driving is the disregard of safety of person or property. In criminal and traffic law, that is essentially the lowest risk that we have, the lowest bar there is. With reckless endangerment, it requires substantial risk of death or serious physical injury. This is essentially the highest bar we have. Now, secondly, unlike reckless driving, reckless endangerment requires a showing of gross negligence. That's that a person is aware of and consciously disregarded the risk. on a technical level, these two offenses are very different. They have different elements and they are very different offenses. Now, as an example, let's say that two guys decide to show off their cars to each other by racing around county roads. These guys have fast cars. They're zipping around over 100 miles an hour. They are passing residential neighborhoods. They are blowing through red lights. They're overtaking and swerving in and out of traffic that exists on the road. Now, if those drivers driving in an indisputably grossly negligent fashion cause a crash that results in the death of an individual, they're going to be charged with gross negligent manslaughter by motor vehicle. It's a 10-year felony. Take that same conduct, and if the crash doesn't result in a death but results in an injury, those drivers are going to be charged with second-degree assault. It's an unintentional battery that is the result of grossly negligent conduct. That's a 10-year misdemeanor. Now let's take that same conduct. Nothing changed, numerous lives endangered, but there's no collision. This is where reckless endangerment would apply. That's where it would fit in. Where we are now, it's a payable traffic citation. In Perry v. State, the appellate court wrote, "The purpose of the reckless endangerment statute is to deter crime before injury or death occurs. This is about deterrence and prevention. We can't keep waiting until these drivers kill or injure members of our community before we finally take them seriously and deal with them." On behalf of the Montgomery County State's Attorney's Office, we urge a favorable report on these bills.
Good afternoon, Chair Smith, members of the committee. For the record, my name is Earl Stoddard. I'm an Assistant Chief Administrative Officer in Montgomery County, testifying in favor of Senate Bills 939 and 940. In the County Executive's Office, I have the pleasure of coordinating both the public safety portfolio as well as the Vision Zero portfolio. In Vision Zero, we often talk about deadly by design for our roadways, but we also rely on the fact that people will generally have to follow the rules in order for those designs to work, even when amended. When drivers don't follow the rules, Maryland largely relies on a system of points and fines to correct behavior. For many, perhaps most users, this system works. However, some drivers have such wanton disregard for the rules and the safety of others that the only remedy is to get them in front of a judge before they kill or seriously injure someone, as Mr. O'Grady referred to. Unfortunately, our current laws do not allow this for individuals like the person who struck Sergeant Kep and others like him. We basically rely on the injuries occurring before we can have the severe consequences that would have prevented the injuries in the first place. That's not an effective system. We put our law enforcement officers and the judicial system in a terrible position where they cannot intervene before the worst outcome has occurred. And that's why we need the changes that are proposed in these two bills. Lastly, I think it's important that as I sit here, I'm representing Montgomery County generally. That means there was unanimous consent from the county council and unanimous support from the county executive. That is exceedingly rare in bills, particularly in bills where we're talking about increasing citation, criminal consequences. And I think it's a reflection of just how important Montgomery County believes this is, that I'm sitting here testifying on behalf of both branches of government, recognizing that this is, we have to be able to prevent these kinds of serious injuries, and our current system of state law does not do that. With that said, I request that the committee forward a favorable report for Senate Bills 939 and 940.
Mr. Stoddard, your words are truer than you know, and as can be attested by, we have a distinguished member of our county council, Dawn Lukey, here. So welcome. I know she's going to come testify in a second. Thank you very much for your testimony. Thank you, Senator King. Just a quick note, we've been joined by a couple of folks from midshipmen from the Naval Academy who are here to observe our proceedings and learn a little bit more about our state and local government. You have most assuredly learned a lot about public service. You're obviously in the line of public service. You're going to have a minimum 4-year commitment once you all graduate. So I don't need to lecture you all on your commitment to our nation and to our state, but you've studied political leaders and historical and naval leaders, obviously in your studies. But if you want to learn about what real public service looks like,
look over to Sergeant Kep here, and learn about his story and his commitment and his journey here today. Sergeant, you're a 10-year veteran, or 9-10 years on the force. I just want to say thank you for being here today, and thank you for your service. I know that I think that's the sentiment of the entire committee, but just really glad to see you here and really appreciative of your testimony and your service to our county and to our state. So thank you very much for your work. With that, I'll turn it over to Senator Folden for questions.
Thank you, Mr. Chairman. So I just want to, before I start, I do want to echo those sentiments. And I saw Sergeant Kep a couple weeks ago, and I'm just glad to see him walking around. It's quite amazing feat this so soon after such a horrific collision. And you know, the Naval Academy is here today, and I find it ironic that the military was actually able to help facilitate through Walter Reed, through our 20+ year war that we've been different theaters of combat across the globe involved in, and our service members coming back. And as a veteran, I see this evolution of things have happened, and I'm glad to see finally that through all that terrible things that we've gotten, we have a good result that comes out of those service members going over in the military, having to respond to get our service members back to some functioning level of health. So it's an important thing, and I thank you, Sergeant Kep. I don't know if you remember seeing me over there at the in front of the governor's mansion, but thank you for that. So I wanted to ask the Montgomery County State's Attorney representative that's here.
Sure.
I want, if you could stand up, I think they're gonna want you to stand at the podium. I know Sergeant Kep's gonna be upset, but they gave him a pass. But you gotta stand up. So I do find this, I agree with whoever said the part about exceedingly rare. This is really exceedingly rare that Montgomery County is coming together in this. And I think, but altogether very appropriate. You know, when I'm familiar with the traffic law of, you know, reckless driving, it talks about a willful and wanton disregard for persons and property. So it's the operation of a motor vehicle with a willful and wanton disregard of persons or property and endangers them. So that's the threshold, right?
Right.
What is the difference between what that language is? Because I don't know that I heard specifically the delineating difference between the way it is now, because I understand the traffic, it only applies to traffic and one applies to the criminal law or the other part. Is there the language in there that's the prohibitive measure that's causing this?
So with reckless driving, we don't have a pattern jury instruction with it because it's a traffic offense. So
Right.
It's not part of the criminal article. We
Yeah,
don't have a pattern instruction.
it's a civil violation.
It's essentially, there's actually two different methods to prove it. It's either driving in a manner that indicates wanton or willful disregard, or pardon me, driving in a wanton or willful disregard, or in a manner that indicates a wanton or willful disregard. And with that slight exception that they include in part 2, there's no requirement of a subjective intent. And I think that is one of the two distinctions between reckless endangerment and reckless driving. Is in reckless endangerment, there is a subjective requirement that the individual appreciated the risks that they were putting our public at and knowing and intentionally disregarded those risks.
I guess that's my question though, because because it's in the criminal article though, not a part of the civil or the transportation article, it's still to me, as a police officer all these years and struggling with this very issue as well, isn't it weird? Doesn't it? So is it because it's only in the criminal article that way and it's not rising to it as through the operation of a motor vehicle? Because it's a willful and wanton act. That's what's there. It's already there. And I think that standard, from what I heard you just say, would also apply to the reckless endangerment, but it's just not allowed to be applied in traffic law. Is that what I'm hearing?
It is. Reckless driving, the wanton or willful disregard, is kind of included and consumed within the standard that would be reckless endangerment,
Correct.
because reckless endangerment is that higher.
Yes.
And there's a little bit of overlap in that the requirement of recklessness and the reckless driving is consumed within it.
Okay.
One major distinction is the risk at which it's putting the community, whereas reckless driving, it's safety of persons or property. Reckless endangerment has a significantly higher standard of substantial injury or death.
Okay. I mean, I understand what you're saying. I think a lot of that goes back to articulation as well as of the officer as well as there. So I think that threshold's there, but whatever we got to do to clean this up, Senator King, I appreciate you bringing the bill and I appreciate your answers. Thank you.
Certainly. Thank you.
All right, Senator West.
Thank you, Mr. Chair. Normally, I don't talk about other bills, but since I've got all these people from Montgomery County here, let me just say that at the end of this week, this committee is going to be voting on a bill to permit the State Highway Administration to put speed cameras on the Baltimore County portions of the Baltimore Beltway. We've never had those before. There's a bill similar was passed 2 years ago, and the cameras have been put on the Jones Falls Expressway, and boy, had they done a great job. The speeding has gone way down on the JFX, and far fewer tickets have been issued than they expected when we passed the bill, because people are slowing down. We hope the same effect occurs in the Baltimore Beltway. And since all these folks from Montgomery County are here, I would suggest that as a follow-on to this bill, you may consider next year coming to us with a bill to put speed cameras on the Washington Beltway to try to slow the traffic down. With that, I love this bill. I thank Senator King for bringing it. I look forward to voting for both of these bills, and congratulations to all.
Is that a question? Thank you very much. Senator James.
Thank you, Mr. Chairman, and thank you to this panel, and thank you, Sergeant Kep. We've heard similar bills concerning just extraordinarily reckless driving. And I'm not from your area. I live in Hartford County, so my life is up and down 95 and sometimes around the Baltimore Beltway. And while everyone's going a little bit faster, I have to admit, myself included, I'm seeing the most extraordinarily fast cars go by me. I mean, they're over 100, they're over 110, because if I'm going 75, they're just blowing past me. And I'm keeping up with traffic. So there's that element of pressure. I'm sure the sergeant doesn't want to hear that, but I want to know from any of your perspective, what is going on with this? Because it's not unique to Montgomery County. And I'm old enough to tell you, been on the road a long time. I've never seen people drive as fast as they've been driving, let's say in the last 5 to 7 years. It's extraordinary. So, and Sergeant, I think you might have some life experience and just wisdom about that. Is there, because, and the reason I'm asking is this is a start, these two bills and some others we're looking at. I hope, but I don't know, because I don't know what is going on in society that this is becoming pervasive. I don't think I'm ever on 95 where I don't see this. So that's almost a daily occurrence.
I believe that it has gotten worse over the past few years. I think COVID behaviors or COVID driving behaviors, and maybe as law enforcement, we were tailoring our response and our duties to kind of coordinate with the COVID-19 issues ourselves, of distancing and things like that. That might have made it a little different from my experience. Again, I'm a traffic centered officer, so I've done, pretty much traffic enforcement, whether it's impaired driving or speed or whatever, for the majority of my career. And that's what I focused on. I think what we mentioned last week in the House for this, the similar bill to 940 here, is that, again, like I said, the phrase, they have no teeth. I think those that do have no disregard for the current speed laws and the current laws as they're written, a fine and points don't matter. I can't tell you how many times for me personally, being on 270, right there at that intersection of 495, being within 5 miles of the Virginia line, how many times I tell people they're going 105, 110, 120 miles an hour on a laser stop, and they say, "Oh my God, am I going to jail?" And my response is, no, you're not in Virginia. You're lucky you're not in Virginia. And they're relieved and astonished. And when I go back and look at that, they paid a fine. and it's a $530 fine and 5 points on your license. And while I consider that very serious and very, severe, if I had, 5 points on your license triggers some driving improvement stuff and you get another ticket and you're, facing a suspension from the Motor Vehicle Administration, there's no teeth to it. There's no backbone behind it that says this is why we need to curb it. And while I don't have statistics on, how the reckless driving laws in the state of Virginia, which are, if you're familiar with them, are certainly much more serious. And I believe it's anything over 80 unless the speed limit's 70, and then it's or anything 15 over. And then I believe if it's a 70-mile-an-hour speed limit, it's anything over 85. So that's an incarcerable offense. Most of the time you go to jail in Virginia for that. And there's no penalty like that. And again, it's not about putting everyone in jail or making everyone lose their license, but there's no benefit to give someone a citation, a traffic citation, when they just don't care about it and say, well, thank God I'm not in Virginia. There's no backbone to it. But to the original question, I do think it has gotten much worse over my short career of 10 years. And I do think COVID might have played a bit to it. And again, I think the lack of strength of our current laws, which hopefully this helps to close that.
I'm just wondering one last thing. When I was young, really shocked. I looked up a first car I ever drove and the horsepower was something like 78, right? We have mopeds that go faster, but and have more horsepower. But so I am wondering, and we can do this later and get back to me, just the nature of cars too. The engines are all now, able to go a lot faster, a lot more horsepower. And by the way, not just luxury cars, but I see a lot of these people are on the younger side and they're not driving a luxury car. They're driving even perhaps what I would call a small car, maybe. But I think what's under the hood is also allowing them and society is encouraging them to, love this horsepower and then, use it with reckless abandon on highways. Is that your sense too, a little bit, that the nature of the cars that for people is a little different?
It might be. I think certainly you have the nicer, sports cars. It certainly in my incident and the situations that I talked about with the individual, it struck me, that being a sports car.
Oh, it was.
It was a Dodge Challenger. But I do think the type of vehicle may not necessarily matter anymore. I have people that are driving a Honda Civic.
That's
just
what
the
I
same as
mean.
They're driving a Ford Mustang, the same speed down I-270 or around 495 or even on Route 29 or whatever roadway you pick in Montgomery County. I don't think that the vehicle necessarily makes the difference anymore.
Well, extraordinarily, my husband just bought one to save money and it has 248 horsepower. This is a Honda Civic. So, well, thank you all. And again, thank you for the bill. And I too am very supportive. Thank you, Mr. Chairman.
Thank you all very much. I see no more questions from the panel, so we will call, is it Don? Former classmate Don Lutke. Captain Warren Jensen.
He already testified.
Oh,
I went,
sorry.
thank you.
Very good. Let me check that off. Is anybody else? He said it. Sarah Sample and John Singh. Ms. Lutke, the floor is yours.
Thank you, Senator Sidner and fellow class of 2000 Maryland Law graduate and Vice Chair Waldstreicher. I am Councilmember Dawn Lutke. I represent the 7th District in Montgomery County on the County Council, and I serve on our Public Safety Committee. I'm here testifying in strong support of Senate Bills 939 and 940, both today. In looking at the bills, I did look back in as much of the electronic history as I could find about our reckless endangerment statute, because I was trying to figure out why motor vehicles were exempted from it in the first place. And of course, the electronic history on the website dies after a certain point, but truthfully, there weren't annotations prior to 2002 on the code section anyway. So I couldn't find that. But I also thought that there are perhaps a host of different scenarios that we are facing today that at that time policymakers weren't contemplating. And to Senator James's point, The horsepower of a regular old vehicle now is much different. And as teaching a new driver, I don't have to teach them how to drive stick now, which is also a factor because everybody's driving automatics, or most are. But some of the situations that could qualify as reckless endangerment if the exclusion of motor vehicles is removed as proposed in the bill would be excessive speeding or reckless driving in heavy pedestrian areas, which is driving at speeds well above the limit where there's high pedestrian traffic, such as near schools, shopping districts, some of our downtown business districts. Road rage incidents, engaging or initiating confrontations on the road that could lead to accidents or direct harm, including using the vehicle as a weapon. Vehicle ramming, speaking of using a vehicle as a weapon, which is deliberately crashing into other vehicles, buildings, or crowds as an act of assault or terrorism. And we know those have occurred not just here in the United States, but abroad as well. Evading police, fleeing from law enforcement in a vehicle in a manner that endangers public safety. Wrong way driving on highways. You would think that's not a thing, and yet that can be a thing. And throwing objects from vehicles, discharging items or projectiles from a moving vehicle, posing a hazard to other drivers, pedestrians, and property along the roadside. I know they've covered some of the statistics and incidents and scenarios that we've seen in Montgomery County alone. And certainly the county has its own Vision Zero policies. We support the state's Vision Zero policies. But from 2019 to 2023, we've had a 13% increase in fatal crashes in Maryland. And most of those, 68% of those occur on our state roadways. So we can and we must do better. And it's also important, since we're talking about both bills, that I remind everyone that both of these bills are necessary in order to close and bridge the gaps that we are currently experiencing that came to light in the factual scenario that played out in Sergeant Kep's case. And to be clear, the driver at issue in that case did not even have a license. So suspending the license would not have really mattered, right? The passage of both bills is needed to ensure that we close those loopholes and also prevent the enabling of those behaviors by others. As you'll note, there's a portion of the bill related to aggressive driving that also deals with individuals knowingly giving their vehicle to someone who has a known history of engaging in this type of behavior. Both bills empower the judiciary with tools that have been missing in dealing with these incidents, and requiring the must appear language for first offenses of aggressive driving allows the court to intervene and have that face-to-face moment, which is critical so that the individual understands the severity of the offense, and also they can not avoid it by paying the fine and failing to appear. The goal is to promote better behavior, to prevent this type of behavior. And if it does happen, to address that with the individual and hopefully get them to change the behavior so it does not happen again. Enacting both bills would allow a win for the community, for the individual who may be affected, for our public safety partners, and for the judiciary in being able to comprehensively address these issues. With that, I ask for favorable reports on Senate Bills 939 and 940. Thank you.
Thank you. Who would like to go next?
Thank you to Senator Sidner and the rest of the committee for having me today. My name is Sarah Sample, and I'm here on behalf of the Maryland Association of Counties, and we are here to support Senate Bill 940. I think our position is pretty straightforward on this. Obviously, there's an alarming increase in the frequency and the severity of the kinds of incidents that you've heard described here today. And this for us is mainly about protecting our workforce. We've got thousands of people that are out on the roadways every day, putting their lives at risk just for doing their jobs. You know, we're talking about school bus drivers and construction workers, DPW and transportation workers, surveyors. We've got a lot of people out there, and more accountability will help us make sure that we can protect them. So we would certainly urge a favorable report on 940. Thank you.
Thank you. Should we go to the China's virtual? Mr. Sang? You have to take yourself off, and there you go.
Yes, thank you. Yes, my name is John Seng. Greeting Chair Smith, Vice Chair Wallstreicher, and Judicial Proceedings Committee members. I'm John Seng, and I represent the Maryland Coalition for Roadway Safety. We're a 4-year-old nonprofit advocacy organization. We strongly support SB 940 as well as 939. Please vote to submit a favorable response. Motor vehicle is indeed a killing machine. 605 people woke up in 2023, but many of them did not see the next morning. Why? Speeding accounted for 161 of those deaths, with 69 tied to aggressive driving and another 113 to impairment. Only a responsible vehicle owner or operator can prevent deaths. Indiscriminately handing over one's keys to another person equates to handing over a loaded gun. Now, Be the Driver is the name of a well-known Maryland safe driving campaign. The campaign reminds drivers to take responsibility, don't drive distracted or under the influence, and more. But Be the Victim is what many innocent people in Maryland got last year. Being nice doesn't cut it with too many bad actors on our roads. Efforts to educate, coach, goad, and beg these self-absorbed, lawless, and greedy perpetrators is pointless while first responders, work zone crews, innocent drivers get to be their victims. To address a point quickly that Senator James made earlier as to why the excessive speeding, I would add that these bad actors know what we all know, that road patrols and enforcement is down. Law enforcement ranks and recruiting have hit Maryland hard, as well as across the country. In fact, the Department of Natural Resources, according to an informed source, the Department of Natural Resources Police in Maryland is the only Maryland law enforcement operation without a major recruiting staffing concerns, which I find frightening. SB 940 says, you with your criminal behavior are unwelcome in Maryland. Change now or get removed from doing any more harm to civilization. And think twice before letting another borrow your vehicle. Approving SB 940 will help ensure that motor vehicle owners choose wisely with their machines that can kill. Please submit a favorable response to SB 940. We thank you and Judicial Proceedings Committee for your consideration.
Thank you very much for your testimony. Any questions from the, I see no questions. Thank you all very much. This ends the hearing for Senate Bill 939 as well as 940. So next is 1037, Senator West. And for the record, Senate Bill 1017 is withdrawn. That's from Senator Alonzo Washington. Senator, the floor is yours.
Thank you, Mr. Chair. It's a pleasure to be here to present Senate Bill 1037. And this bill is about marijuana and the use of marijuana in cars. So when I voted against the marijuana legalization bill a year or two ago, there were two reasons why I voted no. And one of them was the difficulty in apprehending drivers who were driving on the roads under the influence of marijuana. I feared that we would have a difficult time apprehending people, convicting them of driving under the influence, and that we would consequently have more drivers on the roads who were dangerous. So now that marijuana has been legalized in Maryland, it's become more imperative than ever to protect drivers on our roads and our waterways from vehicles and vessels being driven by others who are impaired by drugs. Breathalyzer tests are effective in determining whether a driver is impaired by alcohol, but there are currently no comparable tests for marijuana. One of the core functions of law enforcement officers patrolling the state's roads and waterways is to identify, intervene, and stop drivers who are operating their vehicles or vessels while impaired by drugs. To that end, many law enforcement officers who are assigned to patrolling the state's roads and waterways are trained to recognize the signs of drug impairment and to subject vehicle and vessel operators to validated tests to determine whether they're suffering from such impairment. And for those who are using the state's roads and waterways in the expectation that other vehicle and vessel operators are not driving in an impaired condition, it is important that our law enforcement officers be able to do their work professionally and effectively. Senate Bill 1037 is brought before you today to promote the professionalization of our law enforcement officers and to ensure that when people are caught driving while impaired by drugs come into court, the testimony and evidence against them, which is in accordance with current validated standards, will be received by the courts. So Senate Bill 1037 has two parts. Let me describe each separately. The first part provides that in order to become qualified as an expert witness in the area of drug impairment, a law enforcement officer must have successfully completed a drug recognition training program conducted by a law enforcement agency that was either held in conjunction with the National Highway Traffic Safety Administration or that involved the same requirements for successful completion as the drug recognition program developed by the National Highway Traffic Safety Administration. The bill states that any such police officer may testify on the ultimate issue of whether a driver was driving while impaired. 2 summers ago, along with Senator Kagan, I went down to Montgomery County. I don't know if there's anybody from Montgomery County left in the room. I went down to Montgomery County to their training facility and spent the better part of a day observing how officers are trained to recognize drug impairment on the roads. It was an illuminating experience, and I came away convinced that the officers who were so trained would be totally qualified and should be qualified and accepted by the courts as experts in cases in which testimony was needed about impairment of the driver, who would be the defendant in the case. So that's the first part of the bill. Second part of the bill focuses on a test to determine whether THC was present in the body of a driver. As originally drafted, the bill provided that a concentration of 5 nanograms per millimeter or more of THC in the driver's body would be prima facie evidence that the person was driving the vehicle or vessel while impaired. However, last week, I met with several state experts on THC, and they informed me that because THC affects the brains of different people in different ways, irrespective of the weight of the person involved, the simple 5 nanogram test is not scientifically valid. And therefore, I've prepared an amendment to this bill which permits the results of a test for THC to be admitted into evidence, but merely in order to show that the driver had previously used a substance containing THC. That fact would not be enough to prove impairment in court in and of itself, but would be of assistance to the court in conjunction with the further testimony of a police officer about the results of the officer's impairment tests of the driver. I noticed there are a number of people who submitted opposing testimony or favorable with amendments. In almost all of those cases, they're focusing on the part of the bill which my amendment would take out, the 5 nanogram test, as prima facie evidence. So when they come up to testify, be aware that that language is going to be deleted from the bill before, as a friendly amendment submitted by me, before the bill could be voted on by the committee. With that, as my testimony, I appreciate the committee's consideration of the bill. I hope for a favorable report and would be happy to answer any questions the committee might have.
Thank you very much, Senator. First question is, how illuminating was that experience? I feel like you left some of that, the critical part of that story out.
When I get back to my office, my staff typically puts up on our whiteboard the word of the week. One week I promised Senator Pinsky that I would provide information he asked with alacrity. Alacrity went up on the board. Today, the word illuminating will go up on the board.
There you go. All right, Senator McKay.
Senator, thank you for bringing the bill. Other than the nano part that your amendment's going to take care of, is there anything else that you want to talk about in the unfavorables? Or does that pretty much handle all those?
I think it pretty much handles. I think everybody seemed to be in favor of the first part of the bill, the part requiring sufficient training of the officers in order to admit them as experts in court. I think that, and the second part of the bill just basically says you can introduce the results of such a test in order to show that there was at some time presence of THC, or they had used THC at some point, and there is some residual presence of THC in the body as additional information to fortify or to supplement the testimony of the officers.
Okay, yeah, the amendment seems to do something that you were able to get both the state police and the public defender to be against your bill. That was pretty.
I know.
It's pretty good there.
So it just shows we do read the testimony submitted in our bills and try to take evasive measures to make sure that the bills are acceptable.
Absolutely. Thank you, sir.
Sure. Thank you.
You take evasive measures to illuminate the problem in an expeditious manner. All right, Senator James.
Thank you, Senator West, for bringing the bill and explaining your amendment. I I know that last year, I believe some senator put in a bill to try to roll out like a roadside test for marijuana. And at that point, what I learned, because I didn't know anything about this, was that we don't have a really good, at least roadside
We don't.
test. So all I wanted, just a little clarification, I totally support the bill and concept, is just, what test will be administered so that
I,
the
well-
cannabis level or the THC level could be admitted into court?
Yeah, the
Is there a
test-
test?
sure. This test that you're talking about, when I was down there in Montgomery County, I took the test along with Senator Kagan. They had it's expensive. It's an
Yeah.
expensive piece of machinery.
Right.
And fortunately, it showed neither of us had THC in our systems.
Well, a positive then.
The problem is
Difficult.
the test has not been scientifically validated.
Right.
And so it's a work in progress.
Okay.
And one hopes that sooner rather than later, they perfect the test and validate it scientifically, so that test can be used in these cases, much like a breathalyzer in alcohol cases. The tests that they're using, because we don't have something like
Right.
that, are rather old-fashioned tests. You stand, you are told to close your eyes, tilt your head back, and then take your right hand and touch the end of your nose with your finger. There are several tests. That's the one I remember most vividly, because I was unable to do that. And even though I'd had no marijuana in my system at the time, but that's the sort of test. And as the day went on, the first time they had the people who were the subjects, they hadn't taken any marijuana. And then they went back and they started smoking for a couple of hours. These were people who volunteered to be the subjects that day. And they came back 2 hours later and they took the same tests again, and they weren't as good passing the tests. And then they came back several hours later and took the tests a third time. And you could see as the day went on, their ability to pass the tests dramatically deteriorated.
Right.
So it convinced me that the tests are valid. They're the best we've got.
Right.
And so they're valid to use in court.
So there isn't a blood test right now, is that correct? For
No, I had been under the impression that you could take a blood test. That's the 5 nanogram test.
Yeah.
The blood test, and the blood would show conclusively. The problem, of course, getting a blood test is you're out on the road driving
Yeah.
and somebody's going to stick a syringe in your arm. I don't think so.
Right.
So they would have to make you get in the police car, leave your car on the side of the road, take you to a medical facility, draw blood, wait while the blood was analyzed. It would be a huge hassle. But I was under the impression that would indeed give you definitive information. The answer is it doesn't.
It does.
Because different people have different reactions it's not just their body, it's their brain.
Right.
In their brain when they take THC.
Thank you very
Yeah.
much. Thank you.
Thank you very much, Senator. Seeing no further questions from the committee, thank you very much. I'll bring up the rest of the panel.
Thank you.
So signed up favorable with amendments, we have Mr. Adam Wells and Michael Stewart. Welcome.
Good afternoon, Mr. Chairman, members of the committee. I'm Michael J. Stewart Jr. I am special counsel to the state's attorney for Carroll County, and I'm here to ask for a favorable report on Senate Bill 1037 as amended. I'm focusing on the first part of the bill. That is the bill that asks for a legislative fix to a problem we're getting out ahead of. Right now in the state of Maryland and almost everywhere across the United States, trained drug recognition experts who have been certified, who are law enforcement, can opine in court that someone is impaired while driving and by X, whatever the drug is. That's not changed. That's everywhere. What happened is the Supreme Court, which used to be called the Court of Appeals or the Court of Apples, I like to say, because they upset the apple cart now and then. They adopted the Daubert standard for expert testimony. Daubert Pharmaceuticals has been around since '93. It's a federal standard. It's standard everywhere. So when they did this, nothing has really changed. What has happened is we're asking for a legislative fix because right now there's no opinion from an appellate court in Maryland that says the drug recognition expert can opine as an expert under this Daubert new standard, which really isn't new. It's been around for decades. So we're just not trying to reinvent the wheel here. We're asking you to go ahead and do something that accepted in almost every jurisdiction in Maryland and everywhere else. Because like I said, it's nothing new, it's reliable. And if we don't get this fix, this could twist and turn in the courts for years and years, and you will lose a tool. Law enforcement will lose the ability to do this, and you could have a Daubert hearing in every single jurisdiction, all 24. And the last one that happened in New Jersey, which we'll talk about in a second, lasted 40 days and had 16 experts. And I'm going to defer to an expert. I brought the vehicular homicide chief from Carroll County, Adam Wells, who lives and breathes this, to clear up any questions you might have. Thank you.
Good afternoon, ladies and gentlemen. The only thing I would disagree is I do not necessarily live and breathe this. I'm somewhat familiar with it. My name is Adam Wells. I'm Vehicular Homicide Unit Chief for the Carroll County State's Attorney's Office. And in that capacity, in my 20 years as a prosecutor, I have experienced personally and seen and dealt with the scourge of drug driving and the horrible carnage it creates. Now, why should you support the bill? And I'm talking about the first half of the bill, making it that this shall be accepted by the courts. The DRE protocol has been around and in use since the 1980s. It's been around since almost as long as I've been alive. The case law nationwide has overwhelmingly supported this protocol. No state has discontinued it, and not one state's highest court has nullified it. To date, every single state in the nation, every one, uses this protocol. This protocol is endorsed by a number of professional organizations, including the American Medical Association, the American Optometric Association, International Associations of Chiefs of Police, and NHTSA, to name a few. As spoken, in New Jersey, they held a monster hearing that was 42 days long, 42 days, had 16 experts, hundreds of exhibits, where they evaluated 5,888 DRE opinions and to determine whether or not it fit this Daubert protocol that Maryland now uses. The results was that New Jersey held that, yes, it does fit that Daubert protocol. And on top of that, the DRE reports that they reviewed were corroborated by a matter of up to 90% of the blood draws that were done with regards to those. This would also not be the first time that a state has supported this statutorily. Maine, North Carolina, and Oklahoma have all done this before. Question is, why do we need you guys to do this, and why can't we have the courts do this? Main reason is because the state prosecutors, we cannot appeal this issue, and the defense won't. If we lose one of these hearings, statutorily, we can't appeal it. If we win, we have nothing to appeal. And if we lose, the defense, when we tried this under the old standard and won, defense would not challenge it, because tactically it means in every jurisdiction, in front of every judge, they can keep raising the issue and raising the issue and raising the issue. So for that reason, the only fix would be a bill, and we request your support with that.
Excellent.
Thank you very much.
Thank you very much. Questions from the committee? All right, seeing none, thank you both very much. All right, now we have Haley Mulder sign up in opposition.
Good afternoon, Chair Smith and members of the committee. My name is Dr. Haley Mulder, Chief Toxicologist of the Maryland State Police Forensic Sciences Division. And thank you for the opportunity to provide testimony regarding Senate Bill 1037. The portion of my testimony is in regards to the amended Second Amendment portion that Senator West has just brought up. And that is the mandate of the chemical test for Delta-9 tetrahydrocannabinol, or THC, with a concentration of 5 nanograms per milliliter or more be deemed prima facie evidence that a person is impaired by THC while driving a vehicle or operating a vessel. Whereas alcohol is soluble in water and the concentration in blood can be correlated to the concentration in the brain and its reported effects, THC is different with its interactions, and no such correlation has been established. THC has different interactions with the body, and it makes it difficult to establish such correlations. Impairment by THC is instead established through an officer's observation of the driver and at the time of the traffic stop, and is further supported through chemical tests of blood for the presence of THC in its metabolites. The conclusions of either investigation alone is not enough to conclude impairment of an individual by THC. To marry THC impairment to a single number, such as 5 nanograms per milliliter, is misleading. Numerous clinical studies have shown that there is no threshold concentration of THC in the blood that indicates impairment. With the legalization of cannabis across the United States, it has been shown that consumers of cannabis can have baseline levels of THC present in the body above the 5 nanogram per milliliter level, even after cessation of smoking for over 24 hours. As such, the establishment of a per se law or a zero tolerance policy for THC is discouraged by the forensic toxicology community until there is a better correlation to THC consumption and impairment. So in conclusion, while ensuring road safety and combating impaired driving is paramount to the mission of Maryland State Police, a per se limit for THC as outlined does not adequately address the drug driving problem in Maryland. And with Senator West's with his amendment, which we support, I urge you all to reconsider the appropriate amendment and removing the specific references to prima facie evidence for THC and the number of nanograms per milliliter in the bill. And thank you for your attention, and I'm available to address any questions you may have.
Sure. Seeing no further questions, I guess that addresses your amendment point.
Thank you.
Not on this issue, but state police, I would love, I will probably address this later on, but just for, we're having obviously problems with recruitment and retention across the state. And I wonder if changing some of the requirements with MPTSC for prior cannabis use for recruiting folks, especially for younger folks who are looking to go into the profession might be something we could look at in the years ahead. But that's not this bill this time, but thank you very much. Senator West.
Thank you, Mr. Chair. You recall we passed a bill which I think we passed almost unanimously, maybe unanimously on the floor, and sent over to the House to study police recruitment. And this, I'm sure, will be one of the topics that the study commission will focus on.
Yeah, absolutely. All right. Seeing no further questions, that will end the hearing for Senate Bill 1037. We'll now move on to Senator Sidnor with Senate Bill 954.
Thank you, Mr. Chair. Senator Charles Sidnor, on behalf of Senate Bill 954. Senate Bill 954 introduces various amendments to our Corporations and Associations Act. These proposed changes will align Maryland law with the Federal Corporate and Transparency Act, which requires certain business entities to file beneficial owner information with the financial crime, which is something that's filed with the Financial Crimes Enforcement Network with the Department of Treasury. The CTA created a database of beneficial ownership information within the Financial Crimes Enforcement Network, and the database's purpose is to provide resources to crack down on anonymous shell corporations or companies. The CTA, in placing the burden on businesses, intends to detect, prevent, and punish terrorism, money laundering, and other misconduct accomplished through business entities. Senate Bill 954 has that same goal. First, Senate Bill 954 creates certain definitions, including who an applicant is, who a beneficial owner is, as well as what a reporting entity is. Second, similarly to the CTA, this legislation mandates that a reporting entity must file a report containing the full name, current residential and business address, and an acceptable identification document within 30 days of filing the document that formed the entity. However, if the beneficial owner is a minor, the report need not include the minor's information, but must include the minor's parent or guardian's required information. Third, Senate Bill 954 makes failing to submit a report or filing a report that a person knows contains false information a violation of the law, and the State Department of Assessment and Taxations may impose a civil penalty for each day that the violation continues. This legislation permits the State Department of Assessment and Taxations also to adopt regulations to carry out this law. Finally, under the General Provisions article, Senate Bill 954 states a custodian must allow inspection of a report by a unit of government and the performance of that unit's official duties. This provision also follows the CTA, which permits disclosure of beneficial ownership information in specified circumstances. So Senate Bill 954 contains certain safeguards to prohibit the information from disclosure and is a law enforcement tool that requires transparency to allow the government to solve problems. Ultimately, this legislation, as I said, it mimics the federal CTA and requiring beneficial ownership information to detect, prevent, and punish business entity misconduct. What I also wanted to note, there was a quote from Janet Yellen, who says, in talking about the CTA, that around the world, a lack of transparency, specifically due to opaque corporate structures, makes it easier to conceal illicit activity. Information on beneficial ownership will support our law enforcement colleagues making arrests, prosecuting offenders, and serving ill-gotten assets. Since the introduction of this bill, and I'm just stating for the record, the National Small Business Association, they had filed suit. And I believe it was just last week that I began seeing in my email inbox that in the U.S. District Court down in Alabama ruled the CTA unconstitutional. But I believe it's limited to that specific business owner down in Alabama that had was a plaintiff to the case. I will note that I've had some conversations with Mr. Enton as well as Roy Murray. The way that we had the language drafted, it was a little broader than what it should be. So exemptions for the credit unions, and I believe the way we define banking industry, I think needed to be changed. So the bill was supposed to be completely aligned with the CTA, so it was not placing any extra burdens on any organizations that were not supposed to be, I guess, complying with this. So there will be an amendment that's going to be drafted to ensure that any entities that were exempt under the federal CTA would be exempted under this law. And I think that would take care of most people's testimony that was submitted, except for the MSBA and the MBIA. But in talking, if I may just speak to the testimony that was submitted by the Maryland State Bar Association, their comments was essentially that this bill was a much broader bill, and that we could kind of, if we were to pass Senate Bill 779, which I believe is in budget and taxation, that's a much narrower bill and get to, I guess, the specific problem perceived that has arisen from the use of limited liability entities. But I don't think so. When one looks at Senate Bill 779, when it comes to reporting information about legal owners and the like, I believe from my reading, it says that the person has to identify under oath the correct contact information for a representative of the entity who has the authority to communicate with the public about the entity. That does not get to beneficial ownership type information. For those of you who work in the corporate arena, I mean, you could probably put down a residential agent and get away. I mean, that might qualify for something like this. This legislation, the federal legislation, is attempting to get to a person, an owner, someone who has some money in the game for that entity. This is a tool. This is a law enforcement tool that just 3 years ago was passed in a bipartisan manner by our Congress. The Washington Post on December 7th, 2023, I just wanted to read I think 3 sentences out of an article that was entitled, "Congress Passed a Money Laundering Law. Interest Groups Are Still Fighting It." So it says 3 years ago, when Congress passed an anti-corruption law intended to help combat money laundering through shell companies, it drew bipartisan support. Senator Sherrod Brown, Democrat of Ohio, called it long overdue. Senator Marco Rubio, Republican of Florida, called it an important provision that would help law enforcement agencies crack down on human trafficking and terrorist financing. We've heard a number of bills this session, and we may just still hear a few more, And then most of this, the bills that we've heard, when we talked about public safety, we talked about accountability and the like. So, I mean, many of the things we focused on were individuals. This is something that focuses on individuals that decide to hide behind business entities. With that, I would ask for a favorable report on Senate Bill 954. Thank you very much.
Excellent. Thank you very much. We're going to take questions from the committee and then we'll switch over to the opposition panel. Senator West has the first question.
Yeah, thank you, Mr. Chair. So I'm looking at the fiscal note here and it indicates that the cost is going to be to the state's going to be $2.5 million in order to set up this database program. Have we gotten approval from the Budget and Tax Committee?
No.
Excuse me?
No approval.
No approval. Okay. So we got a money problem. Secondly, let me just give you a hypothetical. There is a local supermarket. We have one in my residential area called Growls. You probably heard of Growls. It's privately owned. They're probably, I'm guessing they're 10 family members who own stock. So would your bill require each of those owners to comply with these requirements?
It's possible if they fall within the definition that was drafted, it's possible that they would be included. I will say that there was a law that was passed by New York State. However, and this was just, I think, signed into law in December of 2023. And what New York did, they, rather than probably being as broad as what this bill would capture, they limited their legislation to limited liability companies. I mean, I'm certainly willing to look at something like that, but really it depends upon the size of the organization and how they decided to organize themselves.
Let me give you a hypothetical at the other end of the spectrum. So you've got Growls, which probably has 10 members of the Growl family who are partial owners of the company. Then you've got another business in my district, McCormick Spices. McCormick is one of the nation's largest corporations. It's publicly traded. There are probably tens of thousands of shares each day traded on the New York Stock Exchange. Does this bill require McCormick?
No, at the federal level, those types of big businesses, the idea is those big businesses have enough information out in the public that we know that they're not being used for money laundering and those types of criminal activities.
Where does this bill exclude McCormick?
As I mentioned, this bill is focused on and written to mirror and to be enforced similarly to what's being done at the federal level.
I just don't see any language in this bill that would exclude McCormick Spices from the purview of the bill.
All right.
And then there's everything in between. There are publicly traded companies which don't have as many stockholders as McCormick.
All right.
There are many small businesses.
Yeah, as I mentioned, the intention of the state legislation is to mirror the federal legislation so that there were no extra burdens being placed on any business entities who have not had burdens that was placed on them at the federal level by the Department of Treasury.
Okay, so we would have to amend the bill to make sure.
You're right. Like I said, there will be an amendment put forth that will exempt any entities that were exempted under the federal legislation.
Okay, I note that in the testimony of the State Bar Association, they report that the National Small Business Association conducted a survey and estimated that the cost of compliance with the federal program would be about $8,000 on average for each business. Would you expect that each business in Maryland would also have about an $8,000 fee to comply with this bill?
I would expect that if it's the same information that's going to the feds, it's going to be the same information coming to us. I do some compliance work within my company, and information that goes to all 50 states, it's the same information. So there's no more of a burden than me producing one report and sending it to one state than it is to send it to 50 other states. The burden is not that, is minimal.
Okay, and the final question is, why do we need this bill? If this information is being provided to the federal government already?
Because it's a very good question.
Why do we need to be provided to Maryland?
Right.
In a way which probably is not going to be SDAT is not the greatest state agency. And
You said that, I didn't.
well, I'm drawing on a lifetime of experiences. So
Tax season's right on the corner. You better watch out.
why would we want the same information to be provided to the state as is already being provided to the federal government and given to a state agency, which might not be really adept at securing the information? So this personal information, private information couldn't leak out through hacking or whatever to people who shouldn't have it.
Right. The reason that I picked the SDAT and thankfully they didn't come in with, at least I didn't see where they came in with any information, but I don't think they want this either. But I thought that since that was the agency that housed information about our business entities, that would be probably the best suited agency to have it in. There certainly may be some other agencies that would better be able to house this information. I'm open to that. I mean,
I guess my question is, why
I'm
ask
getting
that
there.
it be replicated?
I'm getting
if-
there.
Okay.
All right, I'm just a little slow. I'm getting there
That's
though.
okay.
Taking off. Under the Federal Corporate Transparency Act, there are certain government officials, I think banks, there's certain actors that can get the information. At the state level, the only entity that can get this information are state law enforcement agencies, and that's after they file a court order. But what I believe, and this is what the State Bar Association, I believe, were getting at when they talked about Senate Bill 779 as being something that should be considered rather than this bill. What this also gets to are issues that we've heard for years when it comes to vacant properties in Baltimore City and many of the other counties or our jurisdictions around this state. You have business owners who are buying these properties, putting them in, titling them to LLCs, then kind of disappearing, and you're having eyesores sitting in your community. And yes, you have to write down who the resident agent is, but you never find out who owns that property. So you can properly go after who owns that property. So because it is only limited, the federal, and I'm talking about the federal CTA, to law enforcement agencies, this type of legislation actually allows all state and local agencies to have access to that information. So it's not simply just going after money laundering and terrorism and things, but it's going after bad business actors that probably should be having their licenses revoked. But well, not licenses, but we don't revoke folks' corporate charters and things anymore. You get them in. And I mean, back in the day when you had to come and create a corporation, you had to come to the General Assembly and they sign off on your formation. You don't do that anymore. It's just a process. So there are many actors out there that probably don't need to be acting and doing business in the state of Maryland. So it's a way, again, it's corporate accountability.
Okay. Thank you for your answers.
I appreciate your questions.
Sure.
All right, see no further questions from the committee. Thank you very much, Senator.
Appreciate it. Thank you.
Thanks. So now we'll hear from the opposition. Is David Kahn here from the is favorable with amendments? Isn't it Senate Bill 954?
Yeah.
Sorry, my apologies. Hold on. I don't have that sheet. Hold on. We have favorable with amendments before we get to the opposition. So give me one more second here. Can I see that? So just Mr. Enton and Mr. Popham, Bryson Popham. Is that it?
Yeah.
All right.
Thank you, Mr. Chairman, members of the committee, Robert Enton, and I'm appearing before you today on behalf of the Maryland Bankers Association and the American Property Casualty Insurers Association. We are signed up with favorable with amendments. I did meet with Senator Sidnor this morning to talk about the bill. This bill is modeled on the Federal Corporate Transparency Act, which is a recently enacted federal statute and mirrors the language. But the difference is when you look at the federal law, there are pages of exemptions. And those exemptions include banks, both national and state chartered, and insurance companies and others, securities industry and others. My suggestion to the good senator was, because he wanted to mirror, he said, the federal law, have it enacted at the state level, was to adopt an amendment which would include in the state statute the exemptions that are listed in the federal law. And if he did that, obviously, my clients that I'm here testifying on behalf of today would be fine with the bill. So that's why we are signed up favorable with amendments. Thank you.
Thank you, Mr. Chairman. Members of the committee, Bryson Pop, I'm appearing before you, favorable with amendments on this bill on behalf of two clients, the Maryland Association of Mutual Insurance Companies and the Insurance Agents and Brokers of Maryland. Mr. Enton, as he often does, has made my job simpler. I support his amendment because that will take care of our amendments. I do want to point out, if you review the amendments that we offered, the amendment offered on behalf of the insurance agents and brokers was wrong. So I will correct that. It didn't include producers. To Senator West's point, I just want to give the committee a little bit of context here. Our two clients are composed of small businesses. I checked with the Insurance Administration in preparation for this bill today. There are 42,000 licensed insurance producers in the state of Maryland doing business through at least 3,000 corporate entities. Now, those, all of them are subject to extensive provision of information to the regulator. And I believe, I take your point, Senator Sidnor, about this being a law enforcement issue. I think a better way to do it, if I may say so, would be to ask the regulators of certain types of businesses to provide information for you. As for insurance companies, I submitted with my written testimony a 7-page list of reports that insurance companies have to provide to the insurance commissioner. These two types of businesses are extensively regulated. There's lots of information in Maryland regulatory and bureaucratic files on them right now. And I would respectfully suggest their exemption, as Mr. Enton has testified to. Be happy to answer any questions, Mr. Chairman.
Excellent. Thank you both very much. Senator Sidnor has a question.
And this is just to put the question on record from Mr. Enton. For the committee, I did say that I agreed with you and would put in an amendment to deal with the issues of those who are exempt under federal law versus what's in the state.
Yes, and I just would like to point out that the bill as written exempts banking institutions. Banking institutions are state chartered banks. That's the definition of a banking institution. When you look at the federal exemption, it covers both national banks and state chartered banks. But I think if you did what we talked about, then I think you'll get the same information that the federal government gets. But not impose a burden on entities that aren't subject to the federal law.
Very good. Thank you very much.
Further questions from the committee? All right, seeing none, thank you very much. Thank you all. All right, now we will bring up the opposition. Mr. Khan, welcome back.
Thank you. I am not here representing any clients. I am here as the chair of the business law section of the Maryland State Bar Association, purely in a volunteer capacity. In that capacity, we've seen a number of different bills go in that go to getting greater transparency. I've attended several hearings on that topic. Each and every one of the hearings has focused on the use of limited liability entities for residential real estate purposes. And problems with residential real estate owners, landlords, sometimes owners of vacant properties. Okay. I see the rationale behind requiring greater information submitted for residential real property owners. I think it's not fair to paint all of them with a broad brush and say they're all involved in bad activities. But requirements of this nature would help weed out who is not complying and therefore try to enable getting to them. We don't see the rationale for requiring every Maryland limited liability entity that isn't fortunate enough to be represented by great lobbyists like Bob Enton to have to file these reports. And I think the recent ruling that found that the federal CTA is unconstitutional really runs two different ways. The ultimate impact of that ruling is yet to be determined, but let's assume that ultimately that judge's opinion is upheld and the federal CTA cannot be enforced and the federal database is not collected. Well, then Maryland becomes one of only 2 states in the entire country that requires this type of filing by business entities, which I think is a problem. Okay. Questions?
Thank you, Mr. Khan. So you're about to say there was a problem. I'm looking at your testimony on page 2. You talk about the National Small Business Association study, which estimates the cost of compliance with the federal CTA would be about $8,000 on average for each business. If the CTA is found unconstitutional, and Maryland is one of only 2 states in the country which require, would you now expect that the cost of compliance here in Maryland with this bill, which is going to apparently be drafted to mimic this federal CTA, would also be about $8,000 a piece for each of the small businesses in the state?
I think it could be. It depends on the organization of the entity, in fairness. But for more complex entities, we definitely are spending plenty of time trying to figure out who the beneficial owners and especially the controlling persons are, which could be quite expensive.
Okay, and my last question will be, I think Senator Sidney referred to the fact that law enforcement authorities here in Maryland can already get the information that they want from the federal CTA by going to them with, I guess, a warrant. Wouldn't it be a better approach to allow our state's attorneys and the Attorney General's office, if they think there is some criminal activity going on, to single out a particular entity and go to the CTA to get that information rather than requiring every single small business in the state to go through all this paperwork and expense to file these reports?
We certainly think so, yeah.
Okay, thank you.
Additional questions from the committee? All right, seeing none, thank you very much. All right. Oh, here we go. Senator Young is here. All right, Karen Lewis Young. All right, so that concludes the testimony for Senate Bill 954. Thank you, Senator Sidnor. We now have Senator Young is here for Senate Bill 1039.
May I call my panel up,
Yes, please.
Judge Joni Raymond Brubaker, Dana Falls, Lynn Davis, and Danny Wren. Good afternoon, Mr. Chair, members of the committee. I'm honored to be able to present this bill today. This is actually a delegation bill that was voted out unanimously. But I was in a group with colleagues a few weeks ago, and we were all asked, what's your most important bill? And I cited this bill. And no, I don't say that at all my hearings. But the reason I said that is that this bill is designed to help some of our most troubled youth. And that is a challenge that is a priority this session, and in fact, every session. So what this bill does is it establishes a formal truancy reduction pilot program in Frederick County. I'd like to define truancy. It's unlawful absences that are 8 days or more a quarter, 15 days per semester, or 20 more days a school year. Currently, 8 counties have a truancy reduction program. but I will tell you they're all different. And we're going to tell you how the Frederick County program is different as well. Truant youth have about a 75% chance of dropping out, greater chance of dropping out than non-truant youth. Adults who are truant as youths are less likely to be employed, and certainly they have lower incomes when employed. Chronically truant youth participate in more risky behavior, drug and alcohol use, juvenile crime. We've all seen articles that link juvenile truancy to chronic absenteeism, suicidal ideation, and more likely to experience early pregnancy. This is a 4-phase, 6 to 9 month program initiated by a petition from the student school. The court, meaning a judge or magistrate, and a public school liaison work with the family to form a two-pronged approach. We currently have a voluntary informal program in Frederick County, and it's very informal, in fact, funded out of the pockets of the volunteers. But we have some data and some observations already from this volunteer program. 47% of the students participating in the program are now achieving lawful attendance. Our program's slightly different than many of the other programs. I know this can be a controversial subject. This addresses the students' truancy issues at the school level, the community level, and the family level. It is critical to have the family engaged. You see more positive results when the family is engaged. Truancy interventions take into account the family involvement, interorganizational collaboration, accountability, and continuous engagement with the student. I want to tell you about 2 case studies I've observed. I was invited to a hearing, and I watched what I thought was a magical transformation. Young woman came into the hearing. She was frightened. She was nervous. Daughter of a single parent who had to go to work at 7:30 in the morning, and she frequently just didn't get on the bus. She didn't know what to expect. I watched a panel of teachers and therapists and representatives of the court system and counselors all talk to her and encourage her and compliment her. No criticism, no judgment, no reprimands, just reinforcing her strengths. Well, she transformed from someone bewildered and scared and tense to a smile so wide that she looked like Queen for the day. And that made me convinced what a great program that this is. So I said I was going to mention another case study. This one hits a lot closer to home. My 14-year-old grandson, different child today than he was pre-COVID. Good student, great swimmer, single parent, ADHD, couldn't sit in front of a computer for 8 hours a day. Some big behavioral changes, not good ones. We won't go into them here. I observed this program and I learned a lot. And I mean, I knew before watching this program, what agencies were out there, what connections were out there, who I could direct my daughter to, who I could direct him to. But I learned so much from the interactions and the encouragement, and I did it myself with him. I repeated their example. Well, let me tell you the best present I've received this session. Almost perfect attendance, and his report card 2 weeks ago, all A's and B's, because I followed what they're doing. Now, I want to pass it on to the experts. I've given you some micro examples. I want you to hear about the macro. Thanks very much.
Thank you, Senator, first for taking all this on. We really appreciate it. Absolutely. Absolutely. So I want to thank Senator Lewis Young first, who I threw it out there to our local delegation and said, is there anyone who is willing to take on this to present it, to get this bill in front of the Senate and the House? And Senator Lewis Young volunteered to do that. My name is Joni Raymond Brubaker. I am a circuit court judge here in Frederick County, Maryland, here in Maryland. I'm here on behalf of the judiciary. Currently, Maryland Rule 11504 and Courts and Judicial Proceedings 38C02 permit the operation of truancy courts as problem-solving courts in the 1st, 2nd, 3rd, and 7th circuits in the state of Maryland. It's a pilot program. It was initiated back in 2004, and it only authorizes it in those jurisdictions. These are not delinquency courts, as the senator told you. These judges in these courts cannot detain, commit, or shelter these youths. It is the school system and not the state's attorney's office that files that petition. I think we all agree that student attendance rates have decreased significantly since the onset of the pandemic. The senator's example is one of those that we've seen so many of, but especially for students that are Black, Latino, receive special education services, English language learners, and low-income households. They've been hit the hardest by that. And I think you also have seen a lot of legislation with respect to juvenile crime that has been skyrocketing as well. You're all aware that educational disengagement has been identified as one of the early warning signs for delinquency, social isolation, and educational failure. We also know that without a high school diploma or a GED, that these youths are not as employable. They earn less than their graduate counterparts. We know that keeping children physically in school increases their chances of graduation. That's just the simple fact. They have to be in school for that to happen. And it increases their chances for success and giving them a solid foundation. These courts, these truancy courts, Montgomery County has a bill that has come out of Montgomery County tries to rename this educational reengagement, which I love that idea because that's what these courts are really trying to do. They partner with families to determine the root causes for the disengagement from school, and they do a deeper dive than what the schools have been doing. We currently operate a council, and we have some of them you're going to hear from today because we are not an authorized jurisdiction under the pilot program right now for a court. We've been partnering with community stakeholders. We use an access to resources approach. We found that to be successful. We've partnered with our coordinating with community support partnerships. Of course, it's Frederick County Public Schools, but also Spanish-speaking community in Maryland, the Boys and Girls Club of Frederick, the Health Department. We've even partnered a little bit with a mentoring program, I Believe in Me. We are increasing rates of attendance. We're getting needed services to family, the two prongs. We need to get those services to them, but also incentivizing for increased attendance. The youth we see, and our goal is to focus on the elementary and middle school if we possibly can, before those ingrained patterns are in place, before they cross into the delinquency system, which is where I was seeing these youth, and personalizing early outreach to these students. The youth we see are suffering primarily from significant mental health issues, either the youth or parents, because we see that as well, that there are parents with these significant issues that are not ensuring children's attendance and or extreme poverty. We are a motivational and incentive-based program. Our Director of Student Services that you'll hear from, Dana Falls, has been funding incentives out of his own pocket because he believes in the power of what we're doing. And these incentives are not video games. These incentives are things like dinner with the whole family at a restaurant of the youth's choosing, new clothing for unhoused siblings, So they felt better about being in school in clean and appropriate clothing. They've been funding driver's education or getting them driving hours. We had one student who actually wanted to learn more about law enforcement. He wanted to do a ride along, which our local law enforcement is not able to do, but we found a way to engage him in learning more about law enforcement. When I've heard opposition regarding these educational re-engagement courts, they say we need to implement a reward system instead to improve their attendance, that it shouldn't be punitive. That is exactly what this court seeks to do. Our planned court will focus, as we have been, on interventions that are non-punitive. We've provided transportation, removed barriers for unhoused students. We've provided mentoring for these students. The Frederick County Public Schools members of the council have been able to focus more closely on individual academic needs. However, we need to be able to access assessments and evaluations. We need the funds to be able to do that. This gives us a way to get these evaluations to students who are not regularly attending school. We need a coordinator to case manage, go out to the schools, do data collection, liaison with partners. We need the structure and assistance of a problem-solving court to provide these holistic and supportive interventions. And our bill is enabling legislation. It doesn't require this court to start. It enables to authorize us to provide this court. I know there have been comments in the past that schools are already receiving large sums of money. However, all that money that is going to schools does not necessarily assist these youth that we're talking about. IEPs and other interventions are not occurring if these students are not in the school. We're trying to address these students who are regularly not in school. They can only access those services and avail themselves of what that money brings once they are back in school, and we can get them back online once they are in school. Further, getting these youth back into school actually saves the state money long-term by decreasing the chance these youth will enter into the juvenile delinquency system, be less dependent on state benefits. On behalf of the Maryland Judiciary and the bill's sponsor, I urge you to support Senate Bill 1039. Thank you all so much.
All right, thank you very much. We're gonna go to the virtual panelists now. All right. Okay.
Do you want Greta to speak first?
Did you want to speak first, or did you want to?
I wanted to end.
Okay, you want to go again? Oh yeah, excellent. All right, so we'll go with Mr. Falls. Welcome. Hold on, I think we're gonna ask. There you go.
Thank you very much. I appreciate the opportunity to speak on this bill. And thank you, Judge Raymond, for your undying support of our students. Thank you, Senator Lewis Young, for your support of this bill as well. As Judge Raymond indicated, we do have a truancy reduction council that's established with community partners. We have had success with a number of students and families where their whole paradigm of education has been turned around. And we do that with wraparound supports. We do that with partnering with the families and really trying to address root causes. Despite that, there are still times when we don't have the resources that we need to really affect change in the family. And so this bill allows us to advocate or to access another layer of supports that a half dozen other jurisdictions in Maryland already have the opportunity to access. So this enhances and extends what we're currently doing. It would not replace our Truancy Reduction Council. Our volunteer members of community agencies in the school system are committed to that process. And this would allow us to address the needs of those that we're not successful at reaching through the TRC. It is important to really reflect on the court. The problem-solving court would help create some urgency with referrals to community providers and our partners, and help to prioritize some of those students who need priority access to those supports. It also would bring the resources of staffing that would help us to coordinate and again, extend that long-term support for students. One of the things that we have found is that students who are habitually truant, that didn't happen overnight. And typically there's a pattern of behavior that over time we're trying to address to change, and it takes significant time and resources to do that. Thank you very much for your support of this bill. We appreciate the opportunity to speak on it.
Thank you so much. Who would like to go next? Is that Danny? Yeah, can you unmute? Perfect, thank you.
Absolutely. Good afternoon. My name is Danny Wren. I'm a pupil personnel worker for Frederick County Public Schools, and I'm our liaison to the court system. My career in education has taken me from classroom teacher to middle school assistant principal, correctional education principal, and now to the role of PPW. And in every role, there's one main element that could predict student achievement, and that's attendance. In FCPS, many of our students and families have the structures and supports in place to ensure that school attendance is a daily priority. However, there are far too many instances where families, for whatever reason, are unable to make consistent and daily school attendance part of their normal routine. At the school system level, we have made strides with our Truancy Reduction Council to provide resources and incentives to students and families to encourage increased attendance. And in most cases, we see immediate jumps in daily school attendance, and we celebrate those achievements. However, our council has found that sustaining the momentum for many of our students is extremely challenging. Simply put, these students and families need more formal supports, resources, and structure than we can ultimately give them. The formal nature of a truancy reduction pilot program would be a substantial step forward in being able to provide these students and families the necessary means to ensure that school attendance improves and remains consistent. In my previous role before becoming a PPW, I was the principal of the education program at Maryland Correctional Training Center. And I would often meet with our male adult inmates to discuss their educational background and their path to a GED. In almost every case, these inmates told me that their school attendance in their youth was a major problem. When they realized nobody cared, they stopped attending school. In other words, they fell through the cracks. I feel that with the formation of a truancy reduction pilot program, we make sure that no child falls through the cracks in the pursuit of their education. Thank you.
Thank you. Let's hear from Lynn Davis next.
And this is why we do the work. My name's Lynn Davis, and I'm the Supervisor of Mental Health Services for Frederick County Public Schools. And I'm here to share a little bit about why I support this bill. Chronic absenteeism is increasingly in the news, and for really good reason. Students who don't complete their educations generally have poor outcomes in the short term and with lifelong consequences to their future financial and emotional well-being. I'm a licensed professional counselor, and I've been on our county's Truancy Reduction Council for the past 3 years. That's plenty of time to witness what does and doesn't work to help students get back on track. And Mr. Wren and Mr. Falls shared that really well. Many of our students and their parents or their caregivers require support to overcome anxiety-based school refusal. Many parents require support to regain their role as leaders in their family. Many students respond well to earning incentives for their attendance and rising to that challenge. Some require treatment for substance use. Some need frequent connection to positive peers and adults, but getting them engaged is the first necessary factor. All of the strategies above are offered to our students and families by school counselors and social workers and pupil personnel workers long before we get them in the Truancy Reduction Council. And once referred, many take this more seriously and they engage. And however, several need a little bit more encouragement, and we need your help to do that. A problem-solving court will extend what we do and provide the necessary formality to get to the roots of the disengagement so we have enough time with them. Currently, our process is person-dependent and it relies on volunteers. And if we had a problem-solving court, it would help us make better use of available resources and support to get our kids back to school. So passage of this bill will help us do that. Thank you for the opportunity.
Thank you so much. Now we'll hear from our final witness, Mr. Barton. Yes.
Hi, thank you. My name is Gray Barton. I am the Director for the Office of Problem Solving Courts with the Maryland Judiciary. I've been in that position for over 21 years. I oversee the planning, implementation, and sustainability of the 67 problem solving courts in Maryland. Truancy Reduction Court is one part of a continuum of options that students who are absent and disengaged at school. By the time the child enters the program, the school has already been unsuccessful in implementing multiple non-court options. Doing nothing for these students and allowing them to give up on their education is not an option for us. The truancy court is beneficial because it gets students back to school. It identifies barriers in school engagement and provides these children and their families with needed services. For example, in FY 2023, there were 347 students and families that were helped by the truancy reduction courts in Maryland, in the 7 ones. 44% were African-American, 42% were Caucasian, 11% indicated multiple race. In Prince George's County alone, those participating in that truancy court, 53% were Hispanic. And among the 347 students, last year there were 710 referrals for services. That's 347 students, 710 referrals for services. So a great amount of referrals. The highest, 204 referrals for transportation, followed closely by 138 referrals for mental health services. What truancy court is not, it is not a delinquency court or a child in need of assistance court. These courts operate under a different set of statutes. In the truancy court, the court cannot detain, place in shelter care, place in community detention, or set in out-of-home placement. Court Article Title III, Subtitle 8C does not permit that. What this bill will do is allow Frederick County to establish a treatment court to be able to help these students more. Thank you all.
Oh, thank you for your testimony. Do we have questions for the panel of proponents on this bill? Senator James.
Senator, thank you for bringing this bill. Harford County has this, and I think it is really successful. I'm just thinking that when I looked at the fiscal note, there's so many counties that have this, and it seems that they're effective. I'm wondering why we keep calling it a pilot program. In a way, you feel like it just should be a, we have specialty courts, but I guess because you all, this will be your first time having this court. Is that right? That's why
Officially, because right now it exists unofficially.
Oh,
So, I mean, it's a volunteer group
right,
and an informal group. So if you all choose to pass this bill,
right.
It will officially be a pilot program.
All right. Thank you. Thank you.
Gray can give you a little more information on that.
We actually have one question, one answer, but if someone wants to ask Gray a question, he can give, I'll do it. I would love to have some more information on that, Mr. Burton.
Yes.
I'll do it very quickly. It's currently called a pilot program because in 2004, that was the legislation that currently works under. We the judiciaries attempted the last couple of years, as third year in a row to change that, to update that, to amend it, to take out the pilot. But that's how it's currently written in statute.
I'll work with you. Do you need a bill for that? You do probably, right? Well, I support that bill. So,
Thank
all right.
you.
Thank you.
Any more questions for the proponents? Wonderful. There is no opposition panel on this bill, so that concludes the hearing for Senate Bill 1039.
Thank you so much.
Thank you. Next up, I see we have Senator Carrozza here. We will do Senate Bill 961, Senator Carrozza, Wacomico County Vehicle Laws Prohibition on Roadway Solicitations. Welcome back, Senator.
Thank you, Madam Chair. And for the record, Senator Mary Beth Carrozza, representing Maryland's coast, that's Worcester, Wacomico, and Somerset counties. And I thank you for allowing me to present Senate Bill 961, which is a local bill enabling legislation that would prohibit a person from standing in a roadway, medium divider, or intersection to solicit money or donations of any kind from the occupant of a vehicle within Wacomico County only. Senate Bill 961 is modeled after other local enabling bills that already have passed and are in effect in Carroll, Charles, Harford, and Washington counties. Transportation Article 21-507C. Solicitations in roadways pose various challenges and risks to the individuals engaging in this activity, the drivers on the road, the responding officers, and the surrounding community. Since January of 2022, the Salisbury Police Department has responded to 234 calls for service related to money solicitation, and almost all of these calls involved individuals standing too close or directly in active lanes of vehicular traffic. And there have been instances where the solicitors place themselves directly in front of an incoming vehicle. and situations where we've had students where I believe in their exuberance to fundraise are placing themselves on medium strips and putting themselves in danger. Roadway solicitations have become more of a public safety concern in Wycomico County, and prohibiting this action would allow our public safety officers to protect the public and also to assist those individuals who may need assistance due to poverty and homelessness. I do want to point out to you the local bill is supported by the Wycomico Public Schools, the Wycomico County Council, the Salisbury Police Department, and Wycomico Sheriff's Office, and the City of Salisbury, and there are letters in your packet to support that. So I'm asking for your kind attention and swift favorable report of SB 961.
Thank you. Senator McKay.
You can't take care of this locally?
So this was brought to us by the Salisbury Police Department.
Right, but in Wacomico County, with the council, you can't take care of this.
So
locally?
they wanted the enabling legislation. They requested it.
Okay, I'm just surprised that they're not able to do that. I know code home rural counties can do that. I know you're not a code home rural county, but you have a council and exec. So, okay, cool. Sounds like a great plan. Thank you.
Thank you. Any more questions for the sponsor? I don't see any more questions. So with that concludes the hearing on Senate Bill 961, but we get to keep Senator Carrozza with us for one more bill. Senate Bill 976, Vehicle Laws, Annual Vehicle Shows, Motor and Trailer Homes.
Thank you. If I could have my panel join me, I had Jen Evans and Rich Hutchins.
Yes, please have them up. Thank you.
Again, Senator Mary Beth Carrozza for the record, and this is Senate Bill 976. And I appreciate the opportunity to introduce this bill for your consideration. It is a simple clarifying bill that streamlines the statute to make clear that all new Maryland recreational vehicle dealers are allowed to participate in more than 2 annual vehicle shows each year. I will point out to the committee that the bill will be amended to be consistent with the House cross-file to cap that at the number of 3 shows. As way of background, when I introduced Senate Bill 642 last session, which was statewide legislation to allow out-of-state RV dealers to display Maryland RV shows, there was confusion on whether the Maryland law prohibited RV dealers from participating in more than 2 annual shows per year. However, just as we exempted motorcycles from the 2 annual show cap in 2017, RVs are also already exempted under the law as noted in Transportation Article 15-304C3I. So all my bill does this session, what's in front of you, Senate Bill 976, it clarifies that the section of the transportation article under the current statute, it states that these dealers may participate in more than 2 annual vehicle shows if the shows are limited only to Class M motorhomes or Class G trailers. And this seems to be the source of the confusion from last year. Most of these annual vehicle shows are not limited to only Class M motorhomes or Class G trailers, and therefore it's not being consistent with the market and industry operations. So all this bill does is clarify that these dealers are allowed to participate in more than 2 annual recreational shows, and as amended, capped at 3. So again, I appreciate your kind attention and consideration and ask for swift approval of SB 976, and if it would be okay to allow my witnesses to go very briefly.
Yeah, absolutely. Whichever order they'd like to go to, just state your name and I'll mark you off.
Mr. Hutchins.
But please come up to the panel so that the AV system can get you. I'm sorry. Up to the podium. Sorry, I misspoke. Thank you. Go ahead, sir.
Good afternoon, Chairman Smith and members of the Judicial Processing Committee. I'm Rich Hutchins. I'm the promoter for the OCRV show. Today, I'm here to address a current limitation that impacts Maryland's RV industry and the overall success of consumer shows within our state. It including the one I promote in Ocean City. Under the current Maryland law, RV dealers are limited to participating in only 2 shows per year unless they have more than one dealership location. This has become a challenge with the addition of our OCRV show to the existing lineup of shows in Timonium. Most dealers operating from a single location find themselves in a difficult position, having to choose from between these opportunities, which may limit their ability to reach new customers and grow their sales. We aim to complement the existing shows, not compete with them. We believe in expanding opportunities for the RV community to come together, offering more chances for dealers to connect with customers by updating the law to allow dealers to participate in more shows each year. We can create a more vibrant and inclusive environment for the RV enthusiast in Maryland, enriching the RV lifestyle for all involved. This change would benefit not only the dealers by broadening their exposure and potential for sales, but also the consumers by offering them a wider array and view their choices makeover. It would positively impact Maryland's economically through increase in sales and tax revenue. I strongly respectfully request that the committee provide SB 976 with a favorable report. Thank you.
Thank you very much. Who would like to go next?
Good afternoon, Chairman Smith and members of the Judicial Proceedings Committee. I'm Jennifer Evans, and I handle the social media for the Ocean City RV Show. Maryland has an opportunity to significantly enhance its RV industry and boost local tourism by amending the current law that restricts RV dealerships to participate in only 2 shows per year. Allowing dealerships to engage in more shows will not only increase their potential for sales, but also stimulate economic activity across various sectors within the state. First, by expanding the number of shows dealers can attend would directly increase sales opportunities for the dealerships. Each show represents a unique gathering of potential buyers, many of whom travel out of the state, bringing in diverse needs and preferences. More shows means more chances for dealers to connect with these buyers, showcasing their latest models and ultimately closing more deals. Secondly, RV shows are significant tourism drivers, attracting thousands of visitors, if not tens of thousands of visitors, to the hosting locations. These visitors contribute to local economies by staying in hotels, restaurants, and other attractions, thereby spreading their economic benefits around the immediate venue. By increasing the number of RV shows, Maryland can enhance its appeal as a travel destination, encouraging longer stays and repeat visits. A richer RV show lineup would spotlight Maryland as a top spot for RV fans, attracting more outdoor travel businesses and enhancing the state's events. Allowing more RV dealership participation could significantly uplift Maryland's RV market and economy, boosting tourism and making Maryland a go-to for outdoor lovers. And I strongly and respectfully request for this committee to provide favorable report for SB 0976. Just one thing to mention, currently right now in Maryland, there's one dealership who has more than one location. So technically one dealership in Maryland can participate in more than 2 RV shows, but the rest of the dealerships in Maryland cannot participate. Thank you.
Thank you very much.
Good afternoon, Chairman Smith and the rest of the committee. My name is Matt Libber. I'm the legislative chair for the Maryland Tourism Coalition. This is unique for us. We usually don't come in front of this committee very often to talk about tourism. So just kind of give you some highlights. The tourism industry in Maryland is worth $19.4 billion. That saves Maryland taxpayers about $1,000 a year. We employ 187,000 people in the industry. We're the 10th largest private industry in Maryland, and we collect $2.3 billion in taxes that funds about 31,000 public school teachers. So tourism is very important. So that's why we're in support of this bill. The Maryland Tourism Coalition represents the entire tourism industry across Maryland, and including our friends at the Convention Center in Ocean City, the town of Ocean City, and Worcester County Tourism. So this is an important show for them, and they can't draw these dealers to the show because of this limitation. It restricts the amount of tourism that will come along with this and all the businesses around the Convention Center. This show comes at a very important time for Ocean City because it's in the late fall. that is the off-season for Ocean City. So this is driving more people to a tourism destination when they wouldn't normally be there. So it's very important that we lift this restriction. Again, this is the only industry that has that restriction currently, so it makes sense to lift it. So we encourage you to have a favorable report for this bill.
Thank you so much. And rounding us out, Mr. Bariano.
Pleasure to say good afternoon, Madam Chair Kelly. Bruce Bariano, I'm here on behalf of the mayor and city council of Ocean City, and just would repeat everything that everyone has indicated, particularly the gentleman from the tourism. This is very important, Ocean City. The greater use of the convention center brings tremendous revenue, not only to Ocean City, but particularly tax revenues to the state of Maryland. I understand the House is moving this bill favorably by just adding it one more year, making it 3 rather than 2. And would hope you'd pass this out and consistent and promptly. Thank you very much.
Thank you very much. Do we have questions for the panel of proponents on this bill? I am not seeing any questions.
Thank you, Madam Chair.
Thank you all so much. That concludes the hearing on Senate Bill 976. I do not think we have Senator McCray here. So we'll go ahead and do Senate Bill 943, which is my bill, bus vehicle laws, bus obstruction monitoring systems. And I guess I'll present it from here, but my panel can come on up. So let me call them up. We should have Dan Katz here, Charlie Scott, Bob Carlson. I believe virtually we have Ronza Othman, although I know she had a plane to catch, so she may not actually be in the virtual waiting room. She is not. Okay, let's get just a minute for the panel to come up. And then I will introduce the bill and then the panelists can come to the podium. So sorry, everyone's disoriented here. This is, oh, of course, I went to get my talking points and I left them at my desk. Try to be efficient. As I was saying, Senate Bill 943 is the Better Bus Service Act of 2024. The bill is necessary to reduce obstructions to safe, efficient, and accessible bus transit service. In short, Senate Bill 943 allows transit agencies operating in Maryland to deploy fixed and bus-mounted cameras to enforce parking violations that interfere in transit operations. Violations include illegal parking at bus stops and in bus lanes or operating in a bus-only lane. Cameras collect and review this footage, which will be reviewed by a parking enforcement officer. In order to protect privacy, Senate Bill 843 requires all video evidence be destroyed when no longer relevant to the active citation, and the monitoring system cannot use facial recognition for biometric technology. Just wanted to note that for the committee. Washington State just passed similar legislation last night, I believe, joining New York, DC, California, and Chicago and Philadelphia in authorizing bus-mounted cameras to capture bus lanes, bus stops, and other violations. It's really important, and the reason I'm putting in this legislation is that, since New York State passed their legislation in 2019, collisions have gone down on some routes by 34%. Blocked bus stops really present serious hazards for people with disabilities and for seniors. We're going to hear from a panel of experts who will really be able to walk us through why this bill is important. There's no opposition panel on this, but I encourage the members of the committee to ask questions of the panelists here about why it's important. And with that, I will call up Dan Katz, who can walk us through. He's really the expert, but you do have to go to the podium to be caught by our AV system. Thank you.
Thank you, Madam Chairman and members of the committee. My name is Dan Katz. I am Vice President of Public Policy for Hayden AI. Our company works with transit agencies, including WMATA, to help combat obstructions that undermine safe and reliable transit. We request a favorable report of SB 943 because it would enable transit buses operating in Maryland to utilize technology currently authorized not only in DC, but New York, California, Chicago, Philadelphia, and as of last night, Washington State. There are several kinds of camera enforcement systems in transportation right now. For example, speed cameras play a critical role in maintaining safe roads, but bus enforcement is different. In some ways, it's simple math. Bus obstructions undermine the transportation of 40 people as a result of illegal parking by one driver. You'll hear today that the enforcement of illegal parking in bus stops is critical to reduce hazards, especially for people with disabilities and seniors. A blocked bus stop can make boarding dangerous and sometimes impossible for disabled folks because the bus operators are not able to pull the bus parallel to the curb. So a wheelchair access ramp cannot be deployed, and it forces people to literally board the bus walking into a lane of traffic. And that's why agencies across the country are using this tool for bus stops, bus lanes, bike lanes, et cetera. As the chairwoman mentioned, SB 943 includes strong privacy protections, and it requires that the technology is focused on vehicles, not people. This technology does work and does change behavior where it has been deployed. And again, I ask the committee for a favorable report. Thank you.
Mr. Chairman, members of the committee, thank you for the opportunity to testify today. For the record, my name is Charlie Scott. I'm a Senior Government Relations Officer for Metro, and I'm excited that with the passage of this legislation, the Clear Lanes project that we have initiated in the District of Columbia will be able to expand here in Maryland. This committee will soon be receiving similar legislation, House Bill 107 by Delegate Robin Lewis from the House of Delegates. That legislation, though, does not cover enforcement of bus stops. So I strongly encourage this committee to approve this legislation by Senator Kelly as written, because SB 943 covers both bus stops and bus lanes. A quick personal anecdote, I broke my ankle in October, and navigating the Metro bus and rail system on crutches has given me new perspectives on accessibility. In December, right after my doctor allowed me to start bearing weight on my left foot, I was waiting for a bus. A car was parked right where the bus would need to pull up to my stop. When the bus approached, I tried to quickly walk around the car to board the bus. Every step was painful, and I knew I was slow, but I was trying to get there quickly, so not to, burden the other people on the bus. And of course, that bus was also in a lane of traffic, so I was also slowing down the cars behind that bus. This scenario plays out every single day across our region. I recognize that I was fortunate. I'm not in a wheelchair, so I do not need the bus to pull up to the curb and deploy this ramp. I'm not visually impaired, so I do not need to listen for the audible sound of the bus approaching and announcing its destination. For our ADA community, it is crucial that buses have clear access to bus stops. Across the region, our jurisdictions have made investments to ensure that bus stops are ADA accessible, and ensuring that our buses can access these bus stops is the safest way to serve these customers with specific mobility needs. So for that reason, I urge a favorable report. Thank you.
First, thanks for the accommodation here.
Perfect.
We're good. Okay, Mr. Chairman and members of the committee, thank you for listening to my testimony today. My name is Bob Carlson, and I am the former transportation manager for the Community Transportation Association of America. I have lived in Catonsville, Maryland for 33 years and frequently ride public transportation here and in numerous cities. I am also a wheelchair user. My experience as a transit passenger with mobility disability has been a challenge. As a frequent bus rider, I can tell you from experience that buses face many obstacles along their route, especially from other vehicles illegally parking in bus stop zones. Those vehicles prevent the bus operator from safely pulling up horizontal to the curb and deploying the wheelchair ramps that otherwise allowing passengers to board and alight the vehicle safely. I remember many times the bus operator could not get to the curb to deploy the wheelchair ramp. One time the bus operator said he would let me off at the curb across the intersection if that would be okay. I agreed, but then the tail end of the bus blocked the cross traffic when the light changed, which caused safety problems for everyone on the bus and others using the roadway. I have also witnessed on many occasions when the bus operator would apologize to non-ambulatory passengers waiting at the curb that he could not get close enough to allow him to board because of illegally parked cars prevented it. Those disabled people had either to make their way to another bus stop or simply hope that the offending vehicle would soon be moved. I support Senate Bill 943 because it would enable transit buses in Maryland to use cameras to enforce illegal parking in the bus stops that prevented people like myself from accessing buses. Transportation is a right under the ADA, and it is denied when people are denied by vehicles being parked in the crosswalks. It's a problem. This legislation will help ensure that no other passenger is left behind because the bus stop is illegally blocked. Thank you for your time.
Excellent. Thank you all very much. Questions from the committee? Senator Folden.
Thank you, Mr. Chair. So I was looking, thank you for bringing the bill. I was looking through some of the language of the bill, and I'm just, everybody knows I'm not always like a big fan of Big Brother type things and cameras trying to be everywhere. I just noticed that there's a component in here that also was not even really talked about, but it's mentioned in here that it also would include a bike lane. So if I'm reading this correctly, if someone were to stop, stand, or park a vehicle in a bike lane, so if you pull over to the right edge of the road where there's a bike lane marked on the edge of the road to drop somebody off, you'd be in violation of this. Is that correct?
Well,
Dan, go up to the podium.
okay.
You gotta.
So the standard says, as you saw, as you read, stop, park, or standing. A lot of this comes down to the interpretation of the local parking enforcement agency, but
we talked about that.
Yeah. And I think that someone dropping someone off and leaving, it's up to the officer reviewing it, but they probably would not take that.
Well, I get that. So if you read a little further into this, it talks about that it provides for an agency that doesn't have a municipal corporation that doesn't maintain a police force, that they may establish or designate to be able to use this system. So that tells me that they're going to, and that would be monitored by someone that they get to write the rules on. So it wouldn't even be a law enforcement officer. It'd be somebody that's like, oh, you know what? They did pull over there. They stopped. Sorry about it. You get a ticket. Like, that's concerning to me that we're making this such a general part that we're now discouraging people from doing the safe thing by moving to the right edge of the roadway to drop off a passenger, whether you're at a restaurant, whether you're at other, if you're in town and you're at a restaurant, it's raining out, you want to drop your wife off because you don't want her walking in the rain while you go park the car. You're in violation of this. And then, how much is the citation for? Have we even said that part? Like what it's set at, or what it's allowed to be set at?
It's set at $75.
$75. So $75, and then it's retained for up to 6 months or 60 days after the final disposition of the citation. But if you get the citation, you don't pay the citation, it remains out there in perpetuity. Is there
until it's resolved, the agency has the right to hold the video image evidence until it's resolved.
And this camera takes pictures. We discussed this also. It's got to be on the record. It takes pictures. So it has people's faces. It has people adjacent to it, their faces. And we always talk about, oh, he's gone today, about AI and being able to identify people and their privacy. I mean, that's another concern. So I'm asking on behalf of my good friend from Baltimore County that question.
Well, I think rarely you'll see a driver or passenger's face because the cameras just take the back of the car.
Well,
but
that
you're
would
right
be the
about
appropriate way because they're the violator, right? I'm talking about the innocent.
Yeah, they're talking about
bystanders.
pedestrians, right?
Correct.
And our technology has the ability to automatically blur any faces. If the agency wants that, we can automatically do that. So there would be no identifying people.
And what percentage does your company get of each citation?
None. It's a flat service fee.
So but you're getting paid.
We're getting paid, but it's not based on a number of tickets or anything like that.
So, are you getting paid because it's a statewide bill and that you would be using your system, or because you're going to enter into contracts with each municipality according to this?
Yeah, so usually there's, the way it generally works with this kind of enforcement is that our company would work with a transit agency like WMATA or MTA and contract with them to provide these cameras and these camera systems on their buses. And then separately with the transit agency would forward the evidence to the local municipality for our parking authority. They would then review those tickets, and then that side of it in terms of like sending the tickets out, that's on the city side. We only work with the transit agencies to collect.
Okay, I appreciate that. So these are mounted on the bus itself then?
Right.
The vehicle itself. So they're actively recording at all times?
What it's doing is it's only front facing, looking at cars that are parked. And
it doesn't only look at cars that are parked.
Well, yeah, right. Okay. Targeting cars that are parked, right. And what it's doing is it's analyzing what it's seeing. Now, if the AI system that's analyzing what it sees in the road does not see a violation, it just deletes and writes over that video. So, but if it.
So what's the loop?
I mean, it could be a couple days. It could
So
be
it does record and it does have
it records and then it deletes it. But it never leaves the bus. So the way the system works is that there's a computer on the bus and that records and then deletes itself if it's not used. If the camera system says, oh, I think this is a violation, it then sends that video package and the data about where it occurred through the LTE, the internet, to the parking enforcement.
So if I'm understanding you correctly, what this system does is it's all computer monitored, right, through the camera.
Right.
And if something comes within the influence of the lane directly in front of the bus, in one of those bus lanes, it will, because they're not only always traveling in bus lanes. That's the other thing about this. So if it sees something in that general influence of that bus lane, then it will capture the tag data.
Yeah, it's programmed to only capture really two scenarios generally. One is if there's somebody parked in a bus lane and it can tell a difference between a car moving and a car that's parked, right? And the other scenario for bus stops is if the bus is coming and it detects that there is a parked car that is not moving but is in the no parking zone of the bus lane, of the bus stop, it'll collect that video as well, send that on to the parking agency for a human to review it. Is how it works.
Okay. All right. I appreciate you answering my question.
Sure.
We'll make sure you get this. I remember a presentation where, for Baltimore City bus lanes, this technology is used, I think, there's a piece of legislation somewhere in the committee that is going to employ this for bus lanes or expand it for Baltimore City.
We did that a couple years ago.
Yeah, I'll make sure you get a copy of this because it's actually fascinating technology. It uses AI as well to kind of learn and understand the patterns and the pathways, but it's really, really fascinating technology. Also, much like the task force language that we've kind of adopted and plugged in on every task force, or the flashing lights for any new movable camera, we do have language, boilerplate language, to kind of just plug in whenever we do something like this to say that the contractor, the incentives cannot be driven by the number of tickets or citations issued. We have language in there that we kind of drop in to make sure that there's no incentive or a perverse incentive to issue more tickets to,
Need that language to speak.
Here. Further questions from the committee? All right. Thank you all very much. Thanks. I'll call the rest of the witness. Yes.
Thank you.
Yeah. Ronza, welcome back. Welcome. You're up.
Hello. Hello, JPR, Mr. Chair. It's great to be with you again, Mr. Vice Chair, members of the committee. I do apologize for not being with you in person. I'm at a transit station, so you may hear trains and other things behind me. Again, I do apologize. I am the president of the National Federation of the Blind of Maryland. For the record, my name is Ronza Offman. I am the president of the oldest and largest member organization of blind, low vision, and deafblind individuals in the state of Maryland. Currently in Maryland, there are over 125,000 individuals with disabilities, according to the U.S. Census, those disabilities impacting mobility and vision. As a result, there are potentially 125,000 individuals impacted by this bill. This, at its core, is a disability bill. It is an equity bill for those who cannot drive, who do not drive. Our members use buses to get to dialysis, to get to church, to get to work, to get to all kinds of other aspects of their lives and move about their community. As a result, when a bus lane is blocked and when a bus stop or curb cut in particular is blocked, that is hindering us from being able to get to those appointments, dialysis, work, etc. Some people have actually missed their dialysis appointment and have, as a result, become very, very sick. And this is essentially critical for individuals with disabilities to be able to move about their communities. We are very much in favor of this bill. We have been supporting it for a couple of years now, and when Baltimore City passed its bill, it was it really made a difference for our community. And so as a result, we wanted to make sure that the committee heard we really, really need JPR to move this bill and this version of the bill specifically that does protect bus stops. I hear the concerns about AI and about privacy. Cameras are everywhere. There are protections everywhere when it comes to personally identifiable information. Cameras aren't going anywhere. And so if we can use them to preserve the rights and access and independence of our disabled community and make sure they can move about their lives, then I think it's incumbent on the Maryland General Assembly to do so. As a result, my organization and I are urging a favorable report on this version of the bill, and please retain all aspects of it with regard to the bus stops and bus lanes and curb cuts. Thank you so much, and I'm happy to answer any questions the committee may have.
Excellent. Thank you very much. Good to see you. Questions from the committee? All right. Thank you very much.
Thank you. Great to see you.
Likewise. Have a good one. All right. We'll move on to the next panel. Is Dan Reed here? I saw Mr. Reed back there. I think there you are, Dan. Haley Peckett. Sarah Sample. I saw Sarah back there. And Cheryl Fogelhatch. Whoever would like to come up to the podium first, welcome.
Thank you. Good afternoon, members of the committee. My name is Cheryl Fogelhatch. I am a member of the National Federation of the Blind of Maryland, Ronza's organization. We are strongly in support of this bill. Let me tell you what happens when I'm standing at a bus stop and it's blocked. I hear vehicles, big vehicles coming up to it. I can't necessarily hear the automated announcements, and I can't hear if a driver calls out to me. In fact, a driver may not even see me. So I'm hearing a big vehicle, and I've got to think, is it a city bus? Is it a trash truck? Is it a school bus? If I think it's a city bus, I've got to weave through the parked cars and find the openings between the parked cars. I've got to get out right at the speeding traffic we heard about earlier today. And then it may not even be my bus because there's no predictability. If a curb cut and a bus stop are clear and a bus can pull in, there's certainty, and I can find the bus and I can board the bus. If those things are blocked, there is no certainty, no predictability. I risk my life, my limb, and maybe I catch the bus. So I want you to understand that this is incredibly important to us. Thank you.
Thank you for that, Sarah. Thank you.
All right. Thank you to the chair. Thank you to the members of the committee for having me today. My name is Sarah Sample. I'm here on behalf of the Maryland Association of Counties, and we support Senate Bill 943. So we appreciate that this is authorizing when it comes to automated enforcement. It's certainly not a responsibility we take lightly. And it's certainly, with this particular bill, something what we think will bring about more transportation equity across the state. So we appreciate that element. In terms of the relevance across our jurisdictions, we've got 3 jurisdictions with dedicated bus lanes now. We have 1 or 2, I think it is, that are currently under construction. And then we've got another couple jurisdictions that have dedicated bus lanes in the plans that they're going to be rolling out shortly. When it comes to implementation, I think it should be able to be fairly seamless. We've got a few jurisdictions that do already have automated enforcement units. They might be able to go ahead and roll it into that. There are a few that might be establishing them new, depending on who goes ahead and enables this authorization. And because there's a fee associated with it, that can help balance out some of the costs. So we think that's a positive way to get this implemented and rolled out. And then other than that, certainly we appreciate the authorization. We don't take it lightly. We think it'll bring about equity, and we certainly would urge a favorable report. Thank you.
Good afternoon. My name is Stan Reed. I'm the Regional Policy Director at Greater Washington, and we support Senate Bill 943. As I think many have said today, Maryland has a growing network of bus lanes, which give thousands of bus riders a faster, more reliable trip every day. But we only get the full benefit of the public's investment in bus lanes when they're clear and free for buses to move. By allowing local jurisdictions and transit agencies to use bus lane monitoring systems, including traffic cameras, these are shown to be effective at changing driver behavior. My understanding is this bill would also create a work group on curb space management that would provide recommendations on how to manage the many competing uses for the curbside on busy roads, such as bus lanes, bike lanes, parking, deliveries, pickups, and drop-offs. I'm sure many of you get packages from like Amazon and stuff, and there are buildings in the state, like apartment buildings, that get hundreds of packages a day, which all clog up the curb, which block buses, which block parking, which block people trying to get dropped off. It's bad. So this bill will ensure that Maryland busy roads work better for everyone while ensuring that travelers can get where they're going reliably and safely. And we ask for this bill to get a favorable report. Thank you.
All right. Good afternoon, Mr. Chair, members of the committee. My name is Haley Peckett. I am the Deputy Director for Transportation Policy from Montgomery County DOT. And it is a great day to be here in support of SB 943 because in 2 more days, we are going to have a ribbon cutting on the University Boulevard bus lanes, which is the biggest investment to date that we've had in Montgomery County on dedicated bus lanes. 4.2 lane miles. And if we had come to you at this point last year, we wouldn't have nearly as much to be able to immediately roll out in terms of these bus lane monitoring systems. And not only that, we have a lot more in the pipeline. We have 4.5 more lane miles coming later this year with the Great Seneca Transit Network, and we are investing $600 million in a BRT system over the next decade, not all of which, but most of which has dedicated lanes. So we want to make sure that this investment is actually operating well and that the passengers that are riding these buses are actually seeing value. And when there are vehicles that are operating in the bus lanes, then those buses aren't operating as effectively. So just to use University Boulevard as an example, there's over 9,000 bus passengers boarding and alighting just on that corridor every day. And it takes them 20% longer when there's cars and other congestion blocking the roadway. I want to also enforce 2 things that well-operated bus lanes do. When I say well-operated, I really want to emphasize that these cameras, which are a new technology, but one that's been tested in enough states to know that it works well and it really does make a difference in terms of access and safety. First, of course, it brings travel times down for the bus riders. It makes it a more competitive in terms of travel time when you think about getting on the bus. And also it sends a powerful statement to other drivers on the roadway that we are prioritizing our investment in transit and we want to enhance those benefits of sustainability, safety, and equity for all people that are traveling in Maryland. So I urge your favorable report and thank you.
So thank you very much. Haley, so that's gonna be on Friday?
Yes, Friday, I think we have a 10 a.m. ribbon cutting.
What part of University Boulevard?
It's on, so it's just north, like in Silver Spring, like just north of like Colesville area.
Yeah, 4 corners.
Yeah.
Okay, so Dan and I won't be there because I'll be here, but
It's from Dennis Avenue to Amherst, I think.
Okay, great. Right in the heart of D20. All right, good stuff, man.
Yes.
Yeah. All right. Yeah. All right, good stuff. Well, definitely let us know when the next ribbon cutting is for the MoCo delegation. We always would love to be there, especially in D20. So thank you for that. All right, seeing no further questions, thank you all very much. And I think, unless I've missed anyone, I think that's the last panel. So with that, that'll conclude the hearing for Senate Bill 943. We'll now move on to Senator McCray, Senate Bill 1135. Is it Nina who's going to come testify on that? Hey, how are you? Welcome.
Good to go. All right, good afternoon, Chair Smith, Vice Chair Waldstreicher, and members of the committee. My name is Nina Themlis, Director of Government Relations for the Mayor's Office in Baltimore City, here to testify in support of Senate Bill 1135. Senate Bill 1135 is a reintroduction of a bill that the city administration requested last year with the same sponsor. The bill would basically allow us to impound vehicles that have more than $1,000 in automated citations on them. Currently, the city has the authority to impound or boot vehicles that have 3 or more unpaid parking citations. However, we have no separate or additional authority for automated citations. Automated citations are red light camera citations and speeding citations. For a bit of context, in order to reach that $1,000 threshold, you would need to accrue at least 13 red light citations at $75 a piece, or 25 speed camera violations at $40 a piece. There are no additional penalties or fines that accrue on top of the initial citation amount. So you would have to meet those minimum thresholds for each type of citation in order to reach that $1,000 threshold. In last year, in 2023, there were a total of 4,354 vehicles that meet the legislation's criteria, totaling over 133,049 individual violations. That means the average number of violations that would constitute a chronic offender is over 30 violations for each vehicle. This legislation would just be an added tool for the city to be able to prevent or encourage individuals from not violating the law as far as speeding or running red lights. We do treat our automated citation efforts as a way to moderate behavior on our road systems. Before implementing any new red light camera or traffic speed camera, we do conduct a traffic study to ensure that the situation is correct and that we are seeing flagrant violation of the law as far as running red lights or speeding in a corridor before implementation of those cameras. Also, once we see that behavior has been modified, we do remove cameras from those locations over time. So this would just allow us to put automated citations on the same level as our parking violations. And so for those reasons, we would request a favorable report for SB 1135.
Excellent. Do we, all right, the only you remember where we were with this. It just,
yeah.
Is it true that is it conceivable? I know it's a lot of infraction, a lot of tickets, but so under this, then it's conceivable that, let's say I live in Harford County, get all these tickets in Baltimore City. You guys would be able to go to Harford County, take that car, tow that car, impound that car, and within 11 days sell that car?
No, so there is no ability for DOT to impound a vehicle that is outside of Baltimore city limits. Okay. So it would only be for vehicles that are encountered within our city streets. So we would not be going to other jurisdictions. And then as far as the impoundment, last year, there was a lot of conversation around the fact that we have a statutory ability.
11 days.
Yes, to sell a vehicle after 11 days. The current practice is 6 months of minimum, typically holding those vehicles. And if the vehicle owner contacts the city, we will hold on to that vehicle indefinitely while we allow for that individual to pull together the money in order to be able to pay off those violations.
So just to be clear then, so I know the way I read it was I thought that the infraction has to occur in Baltimore City, but that you could go get that car if it were somewhere else in Maryland.
So the $1,000 threshold is only related to violations that are occurring in Baltimore City. Okay. I do not believe that the city has any authority to go to other jurisdictions and pick up their vehicles. I will make sure to get back to you because that is not the intent of the legislation.
Yeah, and then, I mean, I know that it's practice is 6 months, but there's the ability for 11 days. And that's what I think we have to keep our eye on.
Yeah. And so I think that if that is a serious concern of the committee, that we would be happy to amend the legislation to only allow for the immobilization so that a vehicle would not be taken to an impoundment lot, but would still allow us to encounter that individual vehicle's owner to encourage them to pay off those unpaid citations.
And your vision is that most of this activity would take place within city limits, right?
Yes, that the entirety of the vision is within city limits.
Got it. Okay.
Yeah.
Sure. Vice Chair Walser.
Thank you, Mr. Chairman, and I remember their discussion last year. Between last year and this year, I think something happened in the District of Columbia. I don't know if you're familiar with what happened and want to talk about the gentleman who killed 3 people. If not, I'm happy to describe that narrative and why what you're talking about is so important.
Yeah, I mean, I will allow you to go into the details, but that did actually happen, I want to say several days after the committee hearing that we had in this committee room. I'll start and you can fill in the details if that's okay. So there was an individual who caused a fatal accident and they had, I can't recall the entire total, but I believe it was over $16,000 in automated citations on their vehicle. And so that is why like we try and bring it back around, not necessarily to the money, but if somebody is repeatedly violating the law and knowingly speeding at least 12 miles over the speed limit and running red lights, that it's likely that they don't necessarily have concern for other members or other individuals on the road and can cause fatal accidents such as the one that took place last year.
Thank you. And I kind of want to, that was my point. I want to center that. This has nothing to do with revenue. You'd love the revenue, but ultimately when someone's racking up that amount, it's indicia that that person does not care about the law. There's a certain lawlessness happening. That's not someone who can't pay their tickets. When you get up to $1,000, $16,000, that's someone who is actively disregarding the law.
Correct.
And as happened in the District of Columbia, this gentleman disregarded the law to such effect that he killed 3 people. No, in DC. No, my point was just the analogy. DC had the same law that Maryland has. They do not allow the impounding of any vehicles for automated. After 3 people died, DC changed their law because the gentleman killed 3 people. Can I ask one more question just in follow up to the chairman? So you said if, instead of, because of this 11-day problem that I really think is an issue, instead you guys would boot through amendment. In other words, we put an amendment instead of impounding, you boot. Why not just, if you're not doing the 11 days, why not allow us to amend the statute and get rid of the 11 days, put it at 6 months? Like what? Why is that sacrosanct?
Yeah, I wouldn't say that it is. The General Assembly had created that 11-day time frame. I do not believe that the imposition of that 11-day period was at the request of the city. So I don't know how that was determined, but I do not believe that we would have any issue with lengthening that amount of time.
So during that, thank you, Mr. Chair. So during that time frame, are they accruing storage fees?
There are daily storage fees associated with the impoundment of vehicles.
That's why. Because a lot of people are going to start accruing a fee that outvalues their car. So if you're saying up to 6 months, you guys will work with them to repay the fees. But if they're accruing a storage daily fee of whatever it is, I'm sure it's at least probably $50 at least a day.
I can get back to you on what the daily storage fees are, but I recognize your point.
Thank you.
All right. Thank you very much. This has been helpful. Thank you.
Thank you.
All right, thanks. All right, with that, that'll end the hearing for Senate Bill 1135. 870? Senator Kelly, you ready to go? All right, awesome.
Hello. Hi, everybody, Mr. Chairman, Mr. Vice Chair. Hopefully this is a simple bill, famous last words. This is Senate Bill 870, Vehicle Laws, Electric Vehicles Weight Limits. It's really straightforward. It is consistent with policies the General Assembly has taken in recent years to support the adoption of electric, medium, and heavy-duty trucks, my area of expertise, as you know. This bill is going to allow for 2,000-pound weight exemption on state roads for electric, medium, and heavy-duty trucks to account for the weight of the batteries in these vehicles. It essentially copies the same exemption that is already allowed by the federal government and 15 other states on interstate roads. Today, you're going to hear from Ashley Bagwell and Zach Kahn with Tesla. So they're going to really explain to you why we need this. I will say that there's a letter of information from State Highway that is a little bit confusing. So Ms. Bagwell will update us on that. And there are also a couple of letters suggesting an amendment to change the language to zero emissions, which we're fine with. And with that, I will pass it off to Ms. Bagwell, who can fill us in on all the details.
Good afternoon, Mr. Chairman, Mr. Vice Chair, and members of the committee. I'm Ashley Bagwell here this afternoon on behalf of Tesla in support of Senate Bill 870. As Senator Kelly said, this bill is consistent with the many policy measures the Senate and the General Assembly have passed over the years to encourage and incentivize the adoption of electric vehicles, as well as in recent years, similar measures that have done the same thing to encourage the adoption of electric, medium, and heavy-duty sized trucks. Last year, for example, Senator Augustine's Clean Trucks Act passed, and last fall, the administration finalized regulations adopting advanced clean trucks. Here with me this afternoon is Zach Kahn with Tesla, who can speak in detail to this bill, as well as update the committee on what Tesla is doing in the electric, medium, and heavy-duty truck space. As Senator Kelly mentioned, we have had conversations and are continuing conversations with State Highway about information included in their letter of information. I'm happy to elaborate on that to the extent that committee members are interested. With that, Mr. Vice Chairman, I will conclude, and I'm happy to help answer any questions.
Senator McKay.
Oh, should we go to the virtual first? Could we do the virtual testimony first? Is that possible?
I'm sorry, I did not see that. Mr. Khan.
Hi, thank you. Good afternoon, Vice Chair Waldstreicher, Chair Smith, members of the committee. As Ashley mentioned, my name is Zach Kahn. I'm a senior policy manager with Tesla. I want to thank Senator Kelly for introducing this bill, providing a 2,000-pound weight exemption for electric trucks operating on state highways in Maryland. Tesla is a global leader in the deployment of electric vehicles and charging infrastructure. And we recently delivered our first Class 8 trucks to customers in California. This is the Tesla Semi. The Semi has already changed the trucking industry's understanding of what's possible with battery electric trucks. The North American Council on Freight Efficiency in the fall included 3 Tesla Semis from Pepsi's Sacramento fleet in what it dubbed its Run on Less event. The trucks were monitored in real time during delivery operations, and the Semi consistently demonstrated that with fast charging, these trucks can operate throughout the day, with one truck even putting in nearly 1,100 miles of work in a single 24-hour period. One issue, as has been discussed with electric trucks, that they currently weigh more than their diesel equivalents. As battery technology continues to improve and gets lightweighted, that differential will decline. But in the interim, the federal government codified in 2019, in an effort to remove a potential barrier to adoption, a 2,000-pound weight exemption for electric trucks, therefore allowing operators to not lose out on some the ability to haul as much goods as they could with their diesel trucks. This federal exemption applies to all electric trucks utilizing the interstate highway system. And since then, more than a dozen, I think it's 15 states have codified similar weight exemptions for electric trucks using state highway system. It's one of the tools in the state's toolkit that can be used to drive EV truck adoption. Maryland has been a leader in adopting good EV policy and regulations, and this bill would be another instance of them doing everything they can to help truck operators in Maryland adopt electric trucks. Thank you.
Thank you. I apologize for moving too quick before Senator McKay has a question.
Thank you, Mr. Chairman. Ms. Bagwell. I know the good senator knows his answer, but I wanted to try to get it from you.
Sure.
Okay. Great bill, those type of things. Washington County recently, with Mack Truck and Volvo, just did a grand opening of electrified rigs being produced and all that kind of stuff. My only question is, does that still will they fall under this or are they too much the way? That would be my only question. You may not know today, but.
They would be positively impacted by this, I think.
Okay,
And it's possible that someone testifying behind me can speak to that as well.
okay, that's my only concern.
Thank you.
Thank you.
Wonderful. Senator Folden, then Senator West.
Chair. Thank you for bringing the bill. I'm just curious if you would be amenable to this, an amendment of some sort, but these vehicles are not gonna have, because they're electric, they will not be utilizing, they'll be utilizing our roadways. They're heavier. They're gonna put more wear and tear on our roadways, but they don't pay anything into the highway user revenues. Correct?
I am not familiar, Senator Folden, with what additional fees they may be charged.
So normally highway user fees are like captured where? At the pump. So we're not charging them more for registration fees. We're not charging any type of attachment. So I think this is a good opportunity for discussion that we consider an amendment that anytime these vehicles are registered in the state, especially these heavy trucks, that there be an appropriate capturing of the resources that they utilize but don't pay into for the maintenance of them. Because what we're seeing is highway user revenue fees are going down because less fuel's being used, which is a good thing, right? That's what everybody wants. But you can't continue to pound the roads with heavier vehicles and not have maintenance money there, which is where the highway user revenue fees come into play.
Thank you for that, Senator Folden. And I think that in past years, when we've had conversations about electric vehicles, that's been a part of that conversation as well. And I know that as a part of different conversations ongoing in the state with the Train Commission and elsewhere, that's a conversation. I'm happy to follow up with you online to have that conversation. Perhaps it's
So would you be amenable to an amendment? Making sure that we capture.
I am happy to chat with you about that. I guess what I would suggest is that perhaps that's a conversation that is better suited for other conversations that are having that are very similar.
There's a lot of conversations you're having, and I just want to have one right.
Well, no, listen, I think it's a legitimate question. The Train
Yes.
Commission is looking exactly at this.
Who
and
is?
The Train Commission.
And
So the Train Commission's looking at highway user revenue fees for roads that they don't use.
That's
I think-
exactly right. For electric vehicles. Senator West.
Thank you, Mr. Chair. So I guess my questions are along the same lines. I'm looking at the fiscal note in this case. And so the bill itself lets these electric vehicles weigh up to 2,000 pounds more than is currently permitted under the law. And the fiscal note says that extra weight is going to cause 50% more damage to the pavement, and estimates that the cost to the state of reinforcing the bridges alone is going to be $1.25 billion. Do you have any comment about that?
So I'll say this, Senator West, I think these were questions and comments that came up on the House side as well in terms of bridge safety and the like. And I think that this doesn't change anything with regard to bridge weight limits and things like that. If there are limitations for bridges, then these trucks would have to abide by that in the way that trucks have to do that today. Again, I'll say we're happy to have conversations, happy to engage and talk to you about the concerns that you've raised, because again, I think with regard to kind of transportation trust fund revenue, those conversations are already happening with regard to electric vehicles. I think I will say too, not dismissing or minimizing the issue, but I think the percentage of total trucks on the road, electric trucks are probably still a very small number right now as well.
Okay, well, I guess that helps. But I know that the pressure is to increase dramatically the number of electric vehicles in general, including electric trucks. So to be reassured that there are not many on the road right now is nice. But if, because of legislation that we have passed in this body in past years, that number is going to double in 2 years and double again in 5 years. Your reassurance about the current condition is nice, but I think we need to worry about what's going to happen a couple of years down the road.
No, of course. And again, I wasn't trying to minimize or dismiss the issues. I think I wanted to make that point, but also say that I think that is being discussed right now with regard to electric vehicles as well. And so perhaps it makes sense to broaden that discussion.
I think it makes sense. I will say that up until having read this bill and the fiscal note, I wasn't aware that electric vehicles weigh so much more than regular vehicles. That came as a surprise to me. But the entire premise of this bill is that we need to allow much heavier vehicles to use our roads because they're electric vehicles, and the heavier weight comes inevitably when you're talking about electric vehicles. So it's a new consideration that I wasn't aware of. And isn't that so?
No, and I'll just say, Senator West, if I can answer your question, you know what, I think, yes, the batteries do make them heavier, but I think it's balancing that with the environmental benefits that you get from the electric.
There's no question there are
trucks.
environmental benefits. The downside, as the Senator Fulton already mentioned, is
Yes.
lower gas tax revenue on the
Sure.
one hand.
Yep.
And these heavier weights, which cause more road maintenance, bridge maintenance, et cetera. On the other hand.
Absolutely, and not to be
think
the
we've
dead
got it.
horse of the train commission.
I think
I'm
it's
sorry,
dead,
Mr. Vice
yes.
Chairman.
Okay, thank you. I think we understand both the advantages and concerns here. Thank you so much. Any other questions? All right, seeing no questions, that completes the hearing. Thank you, Senator Kelly. Thank you, Ms. Bagwell. Senator Carter, we will now move to your bill. Senator Carter, SJ4.
I think we have one more witness signed up, actually, Mr.
Okay,
Vice
I
Chair.
apologize. We don't have the witness list here.
Oh, really?
And so please, no, come on up.
That's fine. Thank you.
Thank you.
My apologies. And I know you've had a lot of discussion already, so I don't need to rehash your questions or the bill. For the record, Lewis Campion, Maryland Motor Truck Association, we are supportive of this bill. Just 2 points I do want to make, rather than rehash what the bill does. The conversion to electric trucks, you should understand, will result in more trucks on the road, unless or until battery technology improves. The loss is about 25% of payload capacity, which means that if we were at 100% electric, and we're not even at 1% electric, but at 100% electric, without improvement in battery technology, you would need 25% more trucks to deliver the same amount of freight. I want to be really clear about something. The passage of this bill doesn't impede your ability to restrict weights on certain roadways. So the simplest sign that you see everywhere, no trucks over 5 tons, gross vehicle weight rating, that doesn't change. You don't get an extra 2,000 pounds as a result of this bill, right? You still have the ability based on engineering and safety design of a roadway to restrict to a specific weight limit. What this bill does is mirror federal law so that, for example, the 5-axle limit for a tractor trailer is 80,000 pounds. So unless a roadway is specifically prohibited otherwise, you could go up to 82,000 pounds. We have a number of areas in law already, hearing some of the concerns that were expressed already, where we have allowances for additional weight. The most obvious one is at the port. At the port, you can haul 90,000 pounds out of the Port of Baltimore because containerized cargo is so heavy. So there are a number of examples where this does occur. This is only 2,000 pounds, which relatively speaking, compared to some other loads, oversized loads that are permitted loads, is a relatively insignificant amount right now. I'm certainly happy to answer any questions. I know we were kind of concluding the hearing, but we would ask for a favorable report. Thank you.
Oh, I'm sorry. I meant to turn this off.
God bless you, man. All right. All right. Seeing
Thank you,
no
Senator.
thank you all very much. Thank you.
Thank you.
All right, with that, that'll end the hearing. We'll now move on to, I think Senator Washington's here, and then we'll move Senator Carter's. Okay.
She's got one witness.
Okay, you sure? Okay, Senator Carter, you're up with Senate Bill, or is it Resolution 4?
Colleagues, Mr. Chair and committee members, this is something that we don't have that often, but Senator Kelly did introduce us to the concept of a resolution. This is also my first resolution ever. And I guess it's resolution because I think there's a concept upon which we can all agree. And so it's more to offer guidance than to do a legislative mandate, even though that could come later. And so Senate Joint Resolution 4, Division of Children and Youth, Student Truancy from School, Unit Policies and Report. I think that the person that signed up is favorable with amendments. Who I read the testimony. The suggestion was to change the language of truancy to chronic absenteeism. And I think that's a great suggestion and I'd love to do that. So I'm happy to incorporate that into my bill, my resolution. So it does three things. It requests the Maryland State Department of Education to add a section or a unit dedicated to addressing student chronic absenteeism from school. That's one. Two, it directs the Division of Children and Youth in the Governor's Office of Crime Prevention and Youth and Victim Services to develop comprehensive strategies in collaboration with relevant stakeholders to effectively address student truancy. And three, it instructs the division to submit a report to the General Assembly by January 1, 2026 regarding the strategies developed and any proposed legislative changes. I believe we were all rather stunned when we learned of the astronomical chronic absenteeism. It's actually epidemic. I mean, across the state, some jurisdictions, of course, substantially worse than others. I believe there was an averaging of about 46%. Baltimore City in 2023 having upwards of 54%, but even counties such as Frederick having 20.7%. All of the counties actually have truancy or chronic absenteeism rates that we cannot be proud of, and we have an opportunity to do something about it. I think the quickest thing for me to do and the most prudent thing is just go through the resolution so that everybody has a full understanding of where I'm going here. So whereas the Blueprint for Maryland's Future has laid out a comprehensive plan to improve education in the state, whereas it is crucial to address the issue of student chronic absenteeism from school to ensure that all children have equal opportunities to access high-quality education. Whereas the Division of Children and Youth in the Governor's Office of Crime Prevention, Youth and Victim Services is a key unit in state government responsible for overseeing policies and programs that impact the well-being of Maryland's children. Now, therefore, be it resolved by the General Assembly of Maryland that to further the purposes and goals of the Blueprint for Maryland's Future, a section or unit should be added to the State Department of Education dedicated to addressing student chronic absenteeism. Resolved that the Division of Children and Youth in the Governor's Office of Crime Prevention, Youth and Victim Services, that is a mouthful, is directed to develop comprehensive strategies in collaboration with relevant stakeholders. I will end there because I've let you know the three primarily things the bill does. I've also gone through kind of some of the text of the bill. I just want to end with sharing with you some of the ideas that I have when I talk about devising strategies. They should develop recommendations to balance accountability and greater supports for families of students that have chronic absenteeism. They should fund programs, identify programs that address social, emotional, and economic factors contributing to truancy. They should form community partnerships, foster collaborations between schools, social services, and community organizations. They should collect data and analyze and track chronic absenteeism patterns and evaluate the effectiveness of interventions used. They should support alternative education where warranted with some of the older children and support diverse educational pathways, including vocational and online learning options. And so I would urge a favorable report for this resolution. Thank you very much.
We're gonna hear from the panelists and then Senator West has a question. Ms. Edwards-Luce, welcome.
Hi, thank you very much. Good afternoon, good evening almost, Chair Smith, Vice Chair Wallstreicher, and esteemed members of the committee. My name is Aubrey Edwards-Luce, and I'm a resident of Prince George's County and the Executive Director of the Sarah and Neil Meyerhoff Center for Family, Children, and the Courts at the University of Baltimore School of Law. For nearly 20 years, CFCC has operated an award-winning restorative program to help elementary, middle, high school students and their families overcome barriers to school attendance and academic success. We employ a trauma-informed, team-based, incentive-focused, holistic approach that encompasses mentoring, oversight, tutoring, social services, referrals, legal guidance, and other housing referrals to help students and their families. As a longstanding direct service provider, we welcome the collaborative resources and state-level leadership and urge your support for SJ4. After having operated the Truancy Court program, which is now called our Tackling Chronic Absenteeism Project, for 19 years, CFCC is a veteran in the battle to help students attend school ready to learn. We were around 7 years ago when, pursuant to H-Bill 429, the Morgan State University published a report called Winning Strategies on the War Against Habitual Student Truancy, which is full of recommendations to address school truancy across Maryland. We know that SJ4 is not the first legislative action to require a report on school absences, but it is the most recent action that would establish government responsibility and accountability for addressing student chronic absenteeism. Like we tell our TCAP students, taking responsibility is the first step towards change, and we're hopeful that creating a government home for the issue of truancy inside of the Maryland State Department of Education and the executive branch will help turn the tide on attendance for Maryland students. Thank you very much to Senator Carter for being open to our amendments, and we thank you for the opportunity to testify and urge a favorable support. Thank you.
Thank you, Mr. Chair. To the sponsor, I love this. I think the most meaningful 2 hours, 4 hours, whatever it was we spent this entire year was early on when we got the testimony about chronic absenteeism and how it leads directly to crime in the streets and people being killed because they were high school dropouts. So this is great. My problem with the bill is it doesn't read like a resolution. A resolution says we support this and we support this and we support that. This contains active directions, says because pursuant to this resolution, you are directed to do this, you shall do this, you shall submit a report. Can't you turn this into a bill? Because bills do that. Resolutions just say it's our sense that such and such.
I'm certainly amenable to whatever the committee would be willing to support. My thought was this governor's agency is brand new, and what we should focus on is giving this new agency guidance and making sure that their efforts are directed at addressing this problem. That's what I was thinking. And I think that
if it's a resolution, I don't see how a resolution can require some organization to submit a report. A bill does that.
Okay. Well, we could make it SB 4. I mean, so we can work it out, but I don't know. I don't know the answer. I don't know if it needs to be a bill or for resolution, because it doesn't like have any penalty or repercussion if the report isn't done or if these things aren't done. It just says this is what you should do. Whenever we form a task force, there's no penalty for failing. There are a couple of times we've formed a task force and it never meets, and there's no penalty for it never meeting. I think that, I mean, whatever the committees will be, honestly, I would rather have a bill. I was just a little gun shy because every time we try to direct folks to do stuff, there's always seems to be a lot of question and challenge about it. And I really thought this issue is too important, not for us not to weigh in, for us not to address.
I agree.
We
If
need
you
to
turn
address
this into a bill, I will be your co-sponsor.
Okay. Any other questions or comments?
No, I got a comment. I said, thank you for the resolution, and thank you, Senator West, for the comments. That for people that are not, we're not aware of the briefings that we had at the beginning of the session. I think I agree with you, Senator West. They're very, very informative, and the great thing is that they're still on our website. So you go to the MGA website, you can access that for the gun violence, as public health or for chronic absenteeism and truancy and so on. So we had 4 really substantive briefings. I'd encourage folks to go back and look at it. Just want to say, no, that didn't happen accidentally. I mean, that was a very deliberate choice and process. And I did not get a chance to do that before, but shout out Josie Urea, the chief staff who took the lead on organizing that with Josh Prada here. So I want to make sure that folks get the shout out because that's a real public service that's captured and people can access that information for a time immemorial. So that's good stuff. Thank you, Senator Carter.
Thank you very much.
All right. All right, with that, Senator Washington, we are ready for you. Senate Bill 1085, Senator Washington, welcome.
And it's great to be here. Just a point of personal privilege. I was here for that briefing as a member of the EEE committee, and I'm sure we can find a bill to put that on, to attach it somewhere. Just we should figure that out because it is an important education policy and it's a way for us to come together. Greetings. Pleased to be here, Senator Mary Washington, asking for your favorable report on Senate Bill 1085. I know you have heard this bill a few times, but I just want to make sure that we've made a lot of significant changes to the piece. I'd like to bring my sponsor panel up if I could. That would be Margaret Berry, Natasha White, who's virtual, Phil, oh, you're here? Oh, great. Phil Karoom and M. Holcomb. Great. Okay, so you know the problem. Solitary confinement, it goes by many names, special housing units, administrative segregation, disciplinary segregation, restrictive housing. Regardless of the name, the conditions are generally the same. 22 to 24 hours per day spent alone in a cell. The UN has condemned the practice as degrading, inhumane, that it's a form of abuse that amounts to little more than torture by any other name. Others say it violates the 8th Amendment, ban on cruel and unusual punishment. The science says that there are harms created by solitary confinement, and they include creating and exacerbating mental illness. Let me just say, it actually creates mental illness. There are disparate impacts on people of color, that it increases the risk for suicide, particularly among youth, because youth are still developing mentally and physically. I mean, yes, and traumatic experiences, which this is, like solitary confinement, can exacerbate or again create first-time, short and long-term mental health problems. And it's not just the person who is incarcerated who suffers. When someone is in restrictive housing, they are often banned from getting visits and calls from their family. This not only punishes the family, it breaks down the family ties that are crucial to reentry. According to a report by the U.S. Government of Accountability, the Federal Bureau of Prisons recognizes that restrictive housing is not an effective deterrent. Say it again. It is not an effective deterrent for bad behavior, and it can increase future misconduct. Despite this acknowledgement, progress has been slow. In Maryland, we can be proactive and implement this common sense limitations, not a ban, it's a limitations on solitary confinement. The limitations would include no one can be placed in solitary isolation for longer than 15 consecutive days during a 60-day period, and no more than 18 days during a 60-day period. Anyone in restrictive housing must receive mental health assessment within 24 hours. Anyone in restrictive housing must receive 4 hours out of cell time. We must ensure that those in restrictive housing still have access to their educational materials, case management, clergy, and mental health. It also requires that all personnel responsible for supervising individuals placed in restrictive housing complete training, including training on trauma-informed care. The bill requires that anyone placed in restrictive housing receive a statement that includes the facts and circumstances that led to the placement, the reasons why a less restrictive intervention would be insufficient to reduce their risk, and the procedures that will be used to monitor the individual. Now, as I said, there are amendments to the existing bill. We've had conversations both from last year's bill as well as among this esteemed panel here. We have removed the term vulnerable individual, instead create a list of individuals who shall not be placed in solitary confinement. We just use that vulnerable individual just too much. The amendment was made to clarify that these groups are not they're not vulnerable, and that can have a negative connotation. They are members of a group of people that deserve protection. We replaced serious mental illness definition in the bill with the National Institutes of Mental Health definition. We've removed the following portion for the definition of residential rehabilitation. I don't know if hopefully you'll have the amendments, but as an alternative to restrictive housing for an incarcerated person, we changed that to for an incarcerated individual who requires separate housing following placement in restrictive housing. Again, well, actually, it's the second one that was moved. Thank you. I'll be corrected, I guess, in the form. So we made some changes in that definition, which will be made more specific here. There is a fiscal note, and I think I have commented before that the fiscal notes are rather large this year. So I just would suggest that an $11 million fiscal note for this program is perhaps a bit excessive and perhaps would need some additional analysis. Our analysis actually suggests that this could save money. In a 2022 Berkeley report, it found that limiting solitary confinement could save California between $60 and $30 million a year. The Partnership for Public Good estimates that Maryland State's HALT Act will save the state $132 million annually and over $1.3 billion over 10 years. And analysts in Connecticut have estimated that their Protect Act would save the state over $14 million. In conclusion, colleagues, Maryland has years of data detailing the overuse and misuse of restrictive housing. This committee has ample data that the overuse of restricting housing limits possibilities for rehabilitation and in fact exacerbates existing conditions and at the end of the day makes not only the individual restrictive housing less safe, but also our individuals who are charged with managing these facilities. Our panel is Margaret Berry. She's a former clinical director of the Criminal Law and Justice Clinic at American University, Washington College of Law. Natasha White is a returning citizen and advocate with Interfaith Action for Human Rights. Phil Karoum is a retired Maryland Circuit Court judge and president of the Maryland Alliance for Justice Reform, and was recently appointed by the Governor Moore to serve as chair of the Maryland Justice Reinvestment Council. And Ed Holman, a staff attorney at the Disability Rights Maryland. These are my opening remarks. And again, I ask for your favorable report and we'll stand ready for questions after the panel. You can begin, I guess, with Margaret. Okay, yeah. Okay.
And Senator, don't worry, we saw our first $8 billion fiscal note this year. So that was
Good afternoon, everyone. I'm Margaret Barry, and I'm happy to be here, although I was hoping last year when I came that you'd pass this legislation. So hopefully this year, second time we'll be lucky. As the senator said, this is essential legislation to pass. We are torturing people in our prisons. The report this year was that the increase in the use of restrictive housing went up by 39%. This is in the face of all that has been said by the senator, We know what's happening to people in restrictive housing, and yet the use increases. 15 days or more in restrictive housing is considered torture under international law. And the report for 2022 said that there's an average of 42.4 days in restrictive housing in this state. We can't keep on doing this to people because the damage done is extreme. And I wanted to use a little bit of time on the fiscal note, which I just saw this morning. I think maybe the same for you. But the numbers seem to be pulled out of the air. They're suggesting increases in the number of personnel, increases in case management, as well as officers and other staff. The idea of this bill is to reduce the use of restrictive housing significantly. It's asking corrections to do a culture change. And this culture change would have less resources going into restrictive housing and more resources going into alternatives to restrictive housing. And so we want to make sure that that's understood in looking at the fiscal note. As the senator said, other states have reduced their expenditures on corrections by this. And I have a number of statistics that I could add to the senators that would show that. But I'm really here to answer any questions you have. So I'm happy to do that as we go forward. Thank you.
Start. Good afternoon, senators. My name is Natasha White. I'm a directly impacted survivor of solitary confinement, and this is actually the third state that I am working in to limit the use of solitary. I'm the director of community engagement for Interfaith Action for Youth. The problem is solitary confinement causes irreparable damage. I know because I served 4 years in solitary confinement. My brother did 26 years in the Maryland Department of Corrections, and I have seen firsthand women hanging from vents like laundry. I have seen men gnaw their fingers in order to get to a medical trip. Locking people in a cell does not rehabilitate them. Maryland has the highest incarceration rate for Black men. And these are the people you are torturing and then sending home to the community. So now we've tortured the community. The Department of Corrections is always going to say it's going to cost more money to stop torturing people. When in actuality, it saves money. Those numbers come from states that are already passed. New York, Connecticut, New Jersey, California. Virginia's bill is on the way to the governor. Maryland can do better. I keep hearing the word best practice when I come here. I have not seen a best practice yet. And it's a fact that the longer we wait to stop torturing our citizens, the longer we hold our communities and those family members hostage. Having a husband come home after 12 years in solitary confinement and being a stranger to myself and my family was a problem. It's how I ended up in a DV shelter. It's how I ended up stabbed 12 times. Doing 15 years in prison as a direct result of domestic abuse and then 4 years in solitary confinement is how I ended up self-isolating. It's how I ended up so distanced from my family. But I know that my voice has created change in other places and it can do so here. We need to face the reality. We have people that think that the way they're utilizing this punishment is for punishment. This is just a cast away and not deal. Corrections is corrections, right? Let's correct some stuff. Please, please support this bill. We need it. Thank you.
Good afternoon, Chairman Smith, senators. I'm Phil Karoom, a senior judge here in Anne Arundel County, not speaking for the court system. But that said, I want to tell you that when I and other judges sentence people, probably our top goal is that they, after they do their prison sentences, will come back better and less likely to go out and commit new crimes. The goal is for them not to recidivate, and that also would reduce the size of our prison population if they didn't come back. Restrictive housing, I think it is so well established that there can be no question, does the opposite of that. It does not make people behave better when they come back. It increases recidivism. It therefore indirectly results in the increase of our prison populations. So it has exactly the wrong impact. Violence in prisons goes up, mental health problems go up upon release, because 95% of all prisoners will be released. It makes our communities less safe. The studies that have been referred to in states which have adopted this, Illinois and Mississippi, suggest that it can actually save millions of dollars rather than cost millions of dollars. Obviously, the fiscal note is a question here, but I would suggest to you that there are ways that if the Department of Public Safety and Corrections wanted to make this work better, they could, instead of just throwing a fiscal note at it and saying, we don't want to change. For example, administrative segregation less than 17 hours in a 24-hour period does not require all that training. If that were the default setting to go to administrative segregation, then in those 17 hours, a smaller number of people could deal with the more intensive high-end need for restrictive housing. So I urge the committee, this is a bill that you need to pass in some form. Perhaps the fiscal note needs to be worked on, but I urge you to work on it, because the practice is one which is harmful in our prisons and is doing the opposite of what needs to be done. Thank you.
Good afternoon. Thank you. Thank you to the chair, the vice chair, and the committee for the opportunity to testify today. My name is M. Holcomb, and I am a staff attorney with Disability Rights Maryland. Disability Rights Maryland is Maryland's protection and advocacy agency authorized under federal law to advocate for the rights of individuals with disabilities. DRM has documented serious issues in state correctional facilities and advocated for improved conditions in these facilities, particularly in restrictive housing units. As a result of our investigation, DRM filed litigation against the Department of Public Safety and Correctional Services in the fall of 2021 regarding their excessive use of restrictive housing for individuals with serious mental illness. The extreme isolation of restrictive housing, as the senator stated, has really significant impacts on mental health, even when used for only short amount of time, and even when people are double celled. Studies have shown that confining an individual to a cell for 22 hours or more per day can cause depression, trauma, paranoia, anxiety, suicidal ideation, and exacerbate existing mental illness. But the mental health services provided to individuals in restrictive housing in Maryland are inadequate, and we believe constitutionally insufficient. Healthcare records indicate that some individuals do not receive any structured out-of-cell services or mental health programming for months at a time. Part of that, the issue we believe, is that DPSCS under-identifies individuals with serious mental illness, identifying only 6% of people in their facilities as having a serious mental illness. National averages suggest about 20% of people who are incarcerated have a serious mental illness. So we greatly appreciate the senator's willingness to amend the bill to include a definition of serious mental illness aligned with the National Institute of Mental Health's definition. Maryland needs to limit its use of restrictive housing, and it needs to provide adequate mental health services to the people that are in restrictive housing. We urge the committee to support this bill with amendments. Thank you very much.
Thank you all very much. Questions from the committee? No, Senator, we talked about the briefings earlier, and I know you attended, and I think it was great because, I mean, you were able to lend your perspective, and we don't generally deal with those issues in this committee, but this issue is, I wanted to have a briefing on this, and we just did not have the time. So we will focus in on this after this hearing, but thank you very much for the bill. If there are no further questions, I'll move on to the next panel.
Okay. And I apologize, I can't stay to hear the rest. I have voting to do.
Got it. Good luck.
Thank you.
Thank you.
Thank you.
All right, is Judge Joanne Raymond Burbaker here? We had Phil Kroom, Sarah McKinley, Jessica Holliday, Emma Holcomb. Sorry, Jessica Holliday. Emma Holcomb. Oh, yeah, sorry, there you go. All right. We have Timothy Sallant, So then with Sarah McKinley. All right, welcome.
Hello. My name is Sarah McKinley and I'm a student social work intern with the Office of the Public Defender in Baltimore City. Something that is not often considered with individuals in carceral settings is the role that trauma plays in criminal behavior. ACEs are potentially traumatic events that occur before the age of 18. According to the CDC, 61% of the US population has experienced at least one or more ACEs, while 98% of the prison population has experienced at least one or more. ACEs can have long-term negative effects on health and well-being, and the toxic stress from ACEs can negatively impact brain development, the immune system, and stress responses. The trauma of ACEs may be amplified by the harsh conditions of segregated housing, resulting in increased health issues and a decline in functioning that negatively impacts immediate well-being, as well as reintegration upon release. Because correctional settings serve individuals who bring their traumatized and troubled histories into the jails and prisons with them, the characteristics of confinement can trigger PTSD reactions. This makes it essential for anyone working with incarcerated individuals to be trauma-informed, especially when working with individuals in segregated housing, so they are able to appropriately address the effects of trauma. The UN considers all forms of solitary confinement to be torture, and has been reported that the psychological effects are equivalent to physical torture. More than 150 years of research has documented the detrimental effects of solitary confinement on mental health and well-being that can lead to serious and lasting psychological damage. Physical and social isolation combined with sensory deprivation and forced idleness create a toxic combination associated with a variety of harmful effects. For these reasons, the Office of the Public Defender urges this committee to issue a favorable report on Senate Bill 1085. Thank you for your time.
Excellent. Thank you very much. All right, we're going to be joined by one guest virtually. Miss Holiday, you're up. Jessica, welcome.
Good evening. My name is Jessica Holiday, and I'm a law student and research fellow at the University of Baltimore School of Law for Law Center for Criminal Justice Reform. The center is dedicated to supporting community-driven efforts to improve public safety and address the harm and inequities in the criminal legal system. We are grateful for this opportunity to testify in support of Senate Bill 1085. I want to focus on the impact of restrictive housing on incarcerated individuals suffering from mental illness. Restrictive housing is often used as a catch-all for incarcerated individuals suffering from mental health issues. In fact, in 2022, 370 individuals with a serious mental illness were placed in restrictive housing in Maryland. Solitary confinement can cause extreme effects on an individual's mental health, causing psychosis, trauma, severe depression, self-injury, or even suicide. In placing an individual in restrictive housing, they are separated from the world in the same cell for nearly 90% of the day. It's not even a cell, it's usually a box, a square, small box. I would like to quote Ruiz v. Johnson. Segregation units are virtual incubators of psychoses, seeding illness in otherwise healthy inmates and exacerbating illnesses in those already suffering from mental infirmities. By helping mentally ill incarcerated individuals by creating group programming, activities, and recreation to reduce the use of solitary confinement, this bill will improve public safety when these individuals are released and create less trauma in the prison system. For these reasons and many more you've already heard today, the University of Baltimore Center for Criminal Justice Reform supports this bill and urges its passing. Thank you.
All right, thank you all very much. Questions from the committee? All right, thank you very much, Jessica. All right, with that, that'll conclude the testimony for the proponents of the bill. We'll now move on to the opposition panel. And we'll hear from Timothy Sellen, Daniel Lasher, Robert Dean, and Jeff Nines.
For the record, Mr. Sullen had to withdraw today. He had an emergency at home, couldn't make the event today. Thank you, Chairman Smith, Vice Chairman Waldstreicher, and members of the committee for this opportunity to testify. I'm Captain Dan Lasher of the Allegheny County Sheriff's Office, and I'm here today on behalf of the Maryland Correctional Administrators Association in opposition to Senate Bill 1085, along with numerous other state and local officials that are behind me. If they'd stand up so you can see who all is here. Correctional facilities in Maryland are charged with the safe care and custody of the individuals committed to them. A primary mission of every administrator is to ensure that this is indeed being done by their staff and the policies and procedures of their facilities being effectively guided by their staff to accomplish this. We work to provide every possible opportunity to the incarcerated every day. This SB 1085 places restrictions upon correctional facilities that stifle our effectiveness and set limitations that are unattainable, unnecessary, and unrealistic. It severely limits the areas of management that control the peaceful and orderly operation of our facilities. This legislation will only create chaos and disruption within the facilities, leading to an increase in incidents of disruption, physical altercations, and disciplinary issues. When individuals are placed in administrative segregation or disciplinary segregation, it may be at the request of the individual who fears for their life. Perhaps it's at the recommendation of the medical department. Perhaps a hearing officer may place them there to serve detention time, or classification may place them there due to numerous issues or circumstances after a review of their record and charges. Individuals are routinely committed to DHMH, but are held in our facilities until a bed is available in a state facility. They are most often removed from the general population because of their outrageous behavior and inability to associate normally with others. These people usually wait between 4 weeks and 4 months to receive a bed at a DHMH facility. When infractions occur within the facility, such as assaults, thefts, destruction of property, and making of weapons, charges are filed and hearings are held. Disciplinary time may be administered, just as it is done in the judicial system. These individuals are given many varying degrees of discipline, from cell restrictions to lockdown time. Their behavior determines their housing. I know I'm over my time, and I'm sorry. I just want you to look unfavorably upon this bill. We're not the monsters that I think we're being painted here to be, and every one of us invites every elected official to come to any of our facilities at any time. There's nothing to hide there, and we treat people like human beings and only want the best for them. Thank you.
Good afternoon, Chair, committee members. My name is Jeff Nines. I'm the Assistant Commissioner of DPSCS, former warden of North Branch, the only Max 2 facility in the state of Maryland. Incarcerated persons are sent to North Branch due to their serious, violent nature and their behavior. They're sent from the maintaining facilities because of such. We house the most difficult population in the state of Maryland. So with that said, of the 1,076 housed at North Branch, 90% are in general population, and approximately 10% are in some form of segregation, disciplinary or administrative segregation. I'd like to make it clear, though, that only the most violent are single celled. All others are in double cells. These rule violations for the most serious are severe physical assaults on staff and assaults on others, up to and including murder inside the facilities. The function of DPSCS is to ensure the safety of the public, its staff, and defenders inside the facility. If this bill is passed, it would significantly hamper the ability to meet that goal. Please don't be under the assumption that just because a person goes to prison, their criminal activity is over. Just as the prison system itself is there to protect the community in which you live in, segregation is there to protect the staff and the incarcerated individuals trying to do the right thing in general population. Please don't misunderstand my position. Everyone wishes there was no need for restrictive housing. That's just not reality. The reality is there is a need for restrictive housing, but that's not the end of the line. We have multidisciplinary teams that meet with these individuals. We have recreation, outside recreation. We have programming available both in cell and out of cell. We have a tablet system that provides them programming, provides them messages to their family, and phone calls to their family. If this bill is passed, it would severely cripple the amount of staff we would need, and we are severely understaffed as it is. I just ask you to vote unfavorable on SB 1085.
Excellent. Thank you very much. Thank you.
Good afternoon, Chairman Smith, Vice Chair, members of the committee. My name is Robert Dean Jr., and I'm the warden of the Jessup Correctional Institution, the largest maximum security facility in the state. I have been with the department for 20 years and it is my pleasure to be here today. As stated by AC 9s, the mission of the DPSCS is to protect the public, protect the staff, and protect the offenders in our custody. Over the years, through information and investigation, we have unfortunately discovered that there are incarcerated individuals that, while serving their time for other crimes, choose to continue their criminal activity from behind the walls. As a respected gang investigator and a qualified expert in Maryland gangs, I can say with a reasonable amount of sincerity that Senate Bill 1085, as written, will place Marylanders in jeopardy. Parts of Senate Bill 1085 seek to eliminate any placement of known gang members in restrictive housing for the purposes of gathering information and fact-finding. As a former task force member of the current DOJ's public safety initiative, we relish the ability to remove known gang members from the general population as previously stated, and this has proved fruitful in keeping Marylanders safe. Additionally, Senate Bill 1085 would reward bad behavior of incarcerated individuals in our facilities. As written, 1085 mandates that individuals on disciplinary segregation get the exact same privileges and recreational activities as those in the general population. So let me put that in context to you. You could have an incarcerated individual seriously assault an officer, and later, moments later after that, according to this bill, that person would be able to enjoy a movie, that person would be able to eat bags of chips, that person would be able to go on a visit and visit their friends after they seriously assaulted a staff member. Another part of this mandate, it requires that incarcerated individuals be moved to another facility if they self-proclaim safety concerns. As an expert gang witness, I can tell you now that gang members would use this mandate to exploit housing so that they can get to other facilities to assault and possibly carry out hits on other individuals that are incarcerated. So with that being said, I urge you to vote unfavorably for this bill. Thank you very much.
Excellent. Thank you very much. All right. Questions for this panel, Senator West and then Senator Fulton.
Thank you, Mr. Chair. Just an observation and asking someone for a reaction to it. Listening to the first panels, and then this panel, it's like two ships totally passing in the night. The first panel seems to be all the way at one end of the spectrum, saying this is the segregation in this fashion is condemned by the United Nations and is torture. And then your panel says, no, it's not at all. It's the one way we discipline prisoners who are acting up in jail. Do you all ever talk together? Try to see.
It's funny you say that because
one reaction,
we had a conversation with a delegate, and one of the things with restrictive housing in the state of Maryland, that conversation has never happened. It's one side making the allegation and then our side making, and as the captain said, we open it up to everyone to come to our facilities and actually see. And again, individuals in restrictive housing, they do get mental health treatment. They do get mental health services. And I can speak for my facility as the warden. We have mental health professionals that come to that unit every single day and see guys every single day.
Here's my reaction. Suppose we were to turn this bill into a work group this summer, and we would compose the work group equally of people from your side of the equation and the other side. Do you think you all could come together and have productive conversations about this problem?
If I may speak on.
To answer the request to meet with us, because we have asked.
All right. All right.
Great. Thank you very much.
Okay, Senator Fulton.
Thank you, Mr. Chairman. Thank you all for coming out. I want to recognize all of you for coming out here. I appreciate the thankless job at times that you all are dealing with. So I guess what I wanted to know was, you know, when I'm looking at this bill, I am kind of baffled. I'm kind of concerned when I hear, like Senator West brought up, about the differing sides of things. You know, you guys are there, you're on site, you're seeing these things happen. You know, it's a special person to do the job y'all do. Like, I've been in law enforcement for a long time, but I could not do the same job that you all do. I recognize that. But it talks about a vulnerable individual with being as a part of this. And I just find it interesting that we're talking about a vulnerable individual in the facility that we need to, who was placed in restrictive housing. And then we've got to deal, with many other things and then offer up many other opportunities to them because they appear to be vulnerable. Having been someone that's been on different, scenes where the person will plead NCR, not criminally responsible, I'm looking at these and it's just mind blowing to me. So I guess how many of these people that are asking for this measure to be brought forward have visited your facilities? To your knowledge.
Outside of disability rights, Maryland, just, recently, and we actually have a visit with them coming up soon to my facility. No one. So again, this is recent.
Exactly.
That's not true. And what about the people who have actually been in their facility?
Hey, all right, listen. You gotta keep some level of decorum in the chamber. So the senator is asking a question to a member of the panel. The member of the panel is the one who should respond. Everyone's had an opportunity to speak, so please. Thank you very much. Senator, please proceed.
Do you mind standing in the podium, sir?
Again, outside of recently, we have disability rights coming to the facility. That's the only organization that has come to my facility.
Okay.
Outside of
And
that,
how long have you been at Jessup?
I've been the warden there for 2 years,
For 2 years. And how long have you been involved with corrections?
20 years.
20 years.
Yes, sir.
All of them on the state DOC
Yes, sir.
in Maryland?
Yes, sir.
Well, thank you. I guess I understood and I have a concern as well that we're gonna have, you can
Oh,
stay there, sir. I just want to make sure that we're hearing this, that I'm hearing this correctly, is that, we have these people that are in Gen Pop, they create or are involved in a certain situation that requires them to be removed from that, whether it's a violent act or something, or an assault on a CO. And then by the way this is written, that we're putting them in these areas, but then we're going to give them all these luxuries right back. It kind of slaps the face of everything we're talking about here when I'm talking about that there's consequences for actions, because we're literally within a facility that they've already been arrested, convicted, and placed. Now we're giving them the opportunity to now have no responsibility for these actions again. Is that pretty fair to say?
That is very fair to say, and that is what the bill pretty much says, that they are to get all of the accesses, privileges, recreational activities on disciplinary segregation as the general population. There would be no deterrent for doing anything wrong for individuals that we've removed from the community for doing something wrong.
Okay, I appreciate that. And then I know that there's a certain amount of in-service training hours that you guys have to go through.
On the state side, every correctional officer gets 40 hours of in-service training, and that in-service training deals with dealing with vulnerable individuals, dealing with individuals have mental health issues, dealing with working in the segregation unit, recognizing all the signs of trauma.
So the bill is now asking to mandate more hours at these certain areas, but we're already doing many of these things that this bill seeks to do. So I'm just confused.
It's already mandated to the Police and Correctional Training Commission.
And I just want to be sure that's 40 hours every year that every correctional officer goes through in-service training.
In-service training. Yes, sir. Absolutely.
That's a wonderful thing to know, because I know that even law enforcement in the state of Maryland are not required to do 40 hours annually.
And that's an increase. When I started as a correctional officer 20 years ago, it was 3 days.
So it was 24 hours.
Correct.
For the record, in local facilities, 18 is mandated.
Yeah.
Most do more, but 18 is the mandate.
Okay. Well, I appreciate your time. Thank you all for coming out, and thank you for the answers.
Yes, sir. Thank you.
For Mr. Lasher.
Senator?
Your perspective is more from the detention center world.
That is correct.
And can you tell me, has over the last couple of years, the mandates that have come from the General Assembly putting on the stress for the officers to allow, I'm going to use the word privileges, or maybe it could be rights, or trying to make life better for those people who are detained, Has that been more stressful on your officers? And could you elaborate of maybe some of the things that keep on being added to your job without having funding to be able to pay for, to create new opportunities where people are having to be segregated actually just for the right reasons, not necessarily.
Yeah, well,
bad
probably the
behavior?
largest mandate that's come down to us has been the medication assisted treatment. And so we offer well, all of the staff, as a matter of fact, my staff right now are currently all going through additional mandated training on medicated assisted treatment that they get anyway, but they're getting an additional 4 hours right now, last week, this week, and next week, to work with and deal with individuals. And that's one of those unfunded mandates that we first got, that all the counties took on, that we're trying to do. I spoke with my colleagues today. I believe in Carroll County, they've got over 50. I've got over 50. Those are 50 additional people every day who are opioid addicted that we go out and treat with medication and with special counseling, try to get into off-site facilities to get treatment. We're every one of the local facilities, as well as the state, we're all about rehabilitating individuals. On this end of, I thought the fiscal note was very low today when they said 11 million, because I know if I had to do this with the number of people I have to bring them out, even if I were reduced the number in half, I've got 30 odd people today, 37, I think, that are on some sort of segregation or serving some disciplinary time. But to get them out for 7 hours or more a day, there's not enough space. Most of them have to come out alone. They're a threat to everyone else. Or there are those on protective custody who don't want to come out of their cell all day long. There are many sex offenders in for things. The inmates are so knowledgeable about the crimes that other people commit. And, you know, there's this little criminal justice inside the jail. If you come in and you're there for raping a child, the rest of them are, you're fair game. So we have to protect those folks as well. And that sometimes means that their activities are somewhat restricted, only because they've asked for those things. They want to be locked in. They don't want to be out. I can't hold an entire basketball tournament or a bunch of teams for 3 guys who are in that situation. You know, we can't put all these people together. Every day, this is that particular struggle. We're down here today, again, as a group and with our colleagues from the state, to say this reaches so much further than we could even grasp. When you talk, if I had to bring all these people, if every facility here had to bring these people out for this many hours a day alone, we'd have to build additional units. We hold males and females in the local facilities. I'd have to have a new unit for each one just so I could spread them all out and give them their time out. You know, these things just don't exist. So, again, as I'd said, we are very welcome to, when the session's out and you folks are back in your areas, please stop by and visit your facility. We would love to show you and let you sit down and talk to anybody. And, I wanted to point out there quickly, we do get, we're audited every 3 years. Back in the early 80s, the legislature set up the Commission on Correctional Standards, and they set up what the standards of operation are. And they come out and they audit all of the prisons, all of the local facilities. And the only way that you can clear that thing, you have to get 100% compliance. So if they come in and they say you're not doing this right, you have to fix that thing. Everybody gets 100% eventually, even if they didn't get it on day one. But the state has a tool to make sure these things are being taken care of, and that is it. And use that organization as well. Use that commission and send them out and come see us.
Maybe that's what this bill could become, is a report that comes back to us, the General Assembly, taking in consideration those standards that you have to be met every 3 years. Thank you.
Thank you.
Thank you, Mr. Chair. We've been at this for a long time. Senator Washington went through the different iterations of the terms that have changed over time, from segregated housing segregation, restrictive housing, solitary confinement. I was just glancing through the data on the number of states that have actually prohibited this use or severely limited it. Senator McKay has a great question. I remember in 2016, we thought we had progress when I was able to pass a bill that required a report on the use of the solitary confinement, whatever it was called at the time. I'm struggling with understanding. And I heard what you testified to, but I'm struggling with understanding how a training requirement is so overburdensome. When it's so much short of what the real goal is to ensure that it's limited, but that's not my question. My question is, you just invited any one of us to come out to any of the facilities at any time and see for ourselves. My question is, can we do so without making an advance appointment so we can see how things are
You can show
on
up,
the spot without having everything cleaned up and straightened up and tidied up? And
you can come to my facility anytime. You can head up there now if you want, and I'll stand here.
and you'll let us in at any time? No.
Absolutely.
We show up.
Any of the elected officials, you come see me. My door is always open and I have absolutely nothing.
Senator McKay just vouched for you, so I'm posing the same question to all the facilities, okay, not just yours. But anyway, that's important because we often are invited to come out, but we're come out and it's like a tour, there's lunch, there's a tour, there's explanation, it's all clean, bells and whistles are all done. And I'd like to be able to see these facilities at the spur of the moment with an impromptu visit.
Please, anytime at all. And that's open to every one of you or anyone in the entire Senate or anyone in the House. My door is always open and there is absolutely nothing there to hide. And just as they do with the commission, the Standards Commission, randomly pick, inmates if you want to sit down and have a private conversation with, the majority of these people, it's not that they're bad people. They did something wrong that we as a society said you need to serve some time and you go off and do that. And then I have others who are very dangerous and very bad. We would caution you that we're not going to let you go in a room alone with this person perhaps, but we'll stand outside and you can speak and we'll watch. But most of these people, the hope is everybody's fixable. Do your time and go away. It was interesting today that we talked to this because I will tell you, and unfortunately, on my way down here this morning, by the time I hit Hagerstown, my county credit card had been called in on a fraud complaint. And they had an inmate fight in the back and two of my officers are hurt and one's still in the hospital. May have had a heart attack. We don't know yet. But the point, it's a difficult thing. But nonetheless, at the end of the day, we are compassionate to these individuals. We want a better life. If I don't see them return, and in my community, I see plenty of these folks in the street. Cumberland is a small area and we chat, we talk. I get many of them a job. If I can get them a job, I know plenty of folks that do that. So I'm taking up a lot of time just rambling. I'm just like, we're not monsters and you're welcome to come see.
No, I don't think that, but I do think, it's just anything you're expecting company, you clean up. But if they catch you on any random day, it might not look exactly the same. And so that's been something actually what my question does come from. Conversations with inmates over years who have explained that when we come for these tours, we don't see the everyday reality that exists when we're not there for a tour many times.
Please surprise me. Okay.
Thank you.
You're quite welcome.
No, thank you for that, Senator Carter. I've had similar experiences too. So I thank you for bringing that up. We have a work group in the back working on the correctional ombudsman as we speak. So it's a kind of a interesting confluence. All right. Serious question for Robert Dean. Just for some levity here. Have you seen the movie Enemy of the State?
I have. Robert Clayton Dean is his
Will
name.
Smith, Robert Clayton Dean. There you go. All right, there you go. All right, there you go. All right.
I'm Robert Stanley.
There you go. I'm William Colonel Smith Jr. All right. All right. Thanks a lot. Thank you all very much. All right. So now we'll hear from, is Miss Sample still here?
All right, thank you to the chair, member of the committee for having me. Again, I'm Sarah Sample on behalf of Maryland Association of Counties, and I will not take up much more time. You've heard from the professionals, so I'm not going to belabor any of the specific issues. What I just wanted to reiterate is that when it comes to restrictive housing in any of our facilities, it is absolutely not something that they take lightly. And I will say that going out and doing some of those visits is something that when I went and saw some of the facilities, I could be walked through the procedures that they take when they were trying to do everything they can to avoid a restrictive setting for some individuals, which also includes transferring people from different facilities across different jurisdictions. So getting getting on site and actually seeing the facilities is a really big thing, because I think it helps us understand the barriers and what the potential is there. And I'm going to go back on my visits this interim. I've done a couple in the last interim, and I'm happy to have anyone come with me. The other thing I would say is we did mention there was a summer study last year. I'm not sure if that actually came together and happened, but we would love to be a part of that. We think that would be a great step in the right direction. And then that way, maybe, because we're not opposed to any changes. We just want to make sure the changes are possible and that they grapple with the realities in some of these facilities. So I think that collaborative approach that helps build trust and is in partnership is certainly something that we would be supportive of. Because coming here today, I mean, everyone's had to take time to come down here and oppose, and we'd really like to not do that. So yeah, we'd really like to see the collaborative approach moving forward on some of these bills. But for those reasons, we urge an unfavorable report. Thank you.
Thank you very much. Questions for Ms. Sample? All right, with that, that'll conclude the hearing for Senate Bill 1085. We'll now move on to the Vice Chair with Senate Bill 968.
I forgot.
Thank you to the members of the committee. Before us now is Senate Bill 968. It's actually a really good bill, an important one. A number of other states have done what we seek to be doing in this bill. Let me explain to you what this bill does and why we need it. Senate Bill 968 gives standing to a motor vehicle dealer association to request an administrative hearing or seek judicial relief on issues with Maryland's dealer franchise law under the transportation article, which is Title 15. Current law provides that only individual franchise dealers may file an action or seek clarification of the motor vehicle franchise law. For a lot of important reasons, franchise dealers are reluctant to file a formal complaint with the MVA against their manufacturer. The potential adverse consequences from the manufacturer for retaliation outweighs an individual dealer filing a complaint. Now, this committee has heard a number of bills over the years on the dealer franchise law, which for the most part have been an attempt to clarify whether or not certain manufacturer practices complied with or violated Maryland's existing franchise law protections. This legislation will reduce the need for new franchise bills to clarify or update the language in the law. Dealer associations have been given standing in 9 states, and here they are. They're purple states, they're red states, they're blue states. North Carolina, Georgia, Florida, California, Hawaii, Idaho, Montana, Washington State, and West Virginia. And in those states, importantly, there hasn't been a substantial increase in litigation. This Senate bill makes no substantive change to Maryland franchise law. It simply gives a dealer association the ability on behalf of its members to use the current administrative process already set up by MVA. I ask for a favorable report.
Good afternoon, Madam Chair, members of the committee. My name is Peter Kitzman. I'm the president of the Maryland Automobile Dealers Association. We represent 300 franchise new car and truck dealers and our 20,000 employees across the state of Maryland here today in support of Senate Bill 968. The vice chairman did a much better job explaining this than I can. I just want to touch on one brief point. If I was in your shoes, my concern would be, well, hey, are we going to create significant litigation? As the vice chairman said, in the other states, they haven't seen that. I can assure you as the president and CEO of the Maryland Auditors, we do not have the financial wherewithal to be filing multiple lawsuits on a yearly basis. This is, again, our hope is that this standing provision will allow us not to be coming back year after year to try to get language perfect and clarified. I think it will do that. But again, the vice chairman's made all the important points. We'd ask for a favorable report. Thank you.
Madam Chair, I'm Mike Johansson on behalf of the Washington Area New Auto Dealers Association. We also support the bill. You may hear from the opponents very eloquently, of course, that they don't need this bill. That's the Supreme Court already outlines a path for standing for associations. And let me suggest why this is a little bit different. If you look at page 2 of the bill, starting on line 13, specifically in this section of the law grants the right to a dealer or a dealer successor to bring an action at MVA. A dealer is a defined term in the code. I am sure that if the association were to take this matter to MVA today as an association on behalf of a single dealer or multiple dealers, the first challenge to that administrative law judge would be they lack standing. Even if the Supreme Court has outlined standing for federal cases in federal jurisdiction, we don't think that same standard would necessarily apply. But nonetheless, we'd spend the first 6 months trying to figure out whether or not the Maryland Auto Dealers Association meets the 3-point test in the Hunt case. We'd rather avoid that and just kind of get to the matter of the issue. Secondly, I agree with Mr. Kitzmiller and the sponsor that what we're talking about is not coming back to you every year. Last year, we had a bill dealing with warranty reimbursement. We suggested that it was not reasonable for the manufacturers to impose their own hour time guide on a repair rather than the retail guide that we were using, because Maryland law is clear that warranty reimbursement should be based on the price the cost to retail customers. That law was passed here many years ago, but because it didn't specify which time manual to use, we asked you to clarify that piece of the particular franchise law. Well, we could go to MVA and ask that question. Problem is, an individual dealer is unlikely to ask that question because it sounds like they're complaining about their franchisor directly, and that franchisor controls their, basically their entire business. So we think the bill would be helpful. We think it would reduce some of the legislation that you see, and we ask you for a favorable report. Thank you.
Thank you all. I do have a question. I may not be reading the bill correctly, but it looks like it's saying that if an individual has an injury over here, and that individual is not the one going to court, but another group of people will come to court and try to recover the damages for the individual that's not in court. Is that that's how I'm reading this?
Correct. So standing, the way that we read the bill and the way it was intended for the dealer to stand in the shoes of an individual franchise, the association to stand in the shoes of an individual franchise dealer. If there is a third party individual who is suing either a manufacturer or a dealer under 15-213, this wouldn't allow us to stand in the shoes of an individual. The association here could only stand in the shoes of a franchise dealer. That's the intention. We'd be happy to clarify it if you think it's not clear enough.
Well, I guess what I'm trying to figure out is just how this would work in practicality. I'm over here, I'm an individual. I'm the individual. I've been injured. I'm not going to court. I'm not suing anybody. I am a member of an association, I guess, or maybe I don't have to be a member of this dealer association. Maybe I don't. Doesn't say I have to be. So some dealer association that I'm not a member of says, I'm gonna take your injury and go to court. And does that mean the individual will come in as a witness to try to recover for their injury? And if the injury is compensated, the compensation would then go to the association, not the individual. That's how this statute reads.
So the intent of the statute is not that. First of all, it would not be an individual dealer coming to the association and asking us to do it on their behalf. It would be something that applies. Let's just say, for argument's sake, Hyundai has a practice that the dealers and the association think violates the Maryland franchise law. We would file a complaint with NBA as the association. We would be sent to the administrative law judge. We would be intending to get a declaratory judgment saying either it does violate it or it doesn't. We would not be seeking individual damages for an individual dealer. It would be simply to determine whether or not a particular practice or policy violates the existing franchise.
Well, if you read this after the new language, it says may recover damages and reasonable attorney's fees.
But in line 9, I'm looking at the new language. For a dealer association on behalf of itself, a dealer or a group of dealers. So the only new language here is a dealer association, if it were injured, which it's impossible for the association itself to be injured. But on behalf of a dealer or group of dealers, if the association has standing, they could bring an action on behalf of the dealers or group of dealers. And if there were damages, the court could rule, make this determination on damages. And even though it's the dealers association that's bringing the case, the court would rule that those damages go to the individual injured parties, which in this case would be the dealer or group of dealers. So the reference here to persons actually is referring to in the section before the change, which we aren't changing, basically says if a consumer is injured by a practice of a dealer or a manufacturer, just because the MVA penalizes the manufacturer or the dealer for that act, it doesn't prevent the consumer from bringing an action in court against a manufacturer or a dealer for its damages.
I'm getting very confused about this consumer. I don't see that word in here anymore.
Well, that was the reference to if a person suffers injury. Okay.
So this is if a person suffers financial injury, that person could be somebody who's buying a car under the statute. Is that right? So, okay. That's fine. But what I'm reading is that all I'm telling you is the way I'm reading it is that an association that has not been injured is coming into court and without any nexus to the injury, which is, I understand Maryland law and just law in general, you have to have an injury to be a plaintiff.
Unless the statute grants the association standing to stand in the shoes of the injured dealer, which is what this bill would do. You're exactly right. Without this bill, the association would not be able to file suit or take an MVA action because the law requires the party to be injured or have a stake in it. So that's why we believe this bill is necessary.
And then why do you, I heard the sponsor say, it seemed like his belief was that this law is needed because of fear of retaliation. But I just thought to myself, well, I don't know if the person who's been injured can hide. So whether it's the person that's been injured or the association, there's no way to keep that person secret, is there? So in that sense, I don't know how you would be avoiding the fear of retaliation.
Again, as far as the association is concerned, we would not get involved in a situation or use our ability to have standing for an individual person who's been injured. It would be again, a practice or a policy of the manufacturer that we believe violates Maryland franchise law. We would go to MVA, go to the ALJ and be seeking a declaratory judgment. I can't imagine damages is really ever going to be part of what, because you're right, the association is not going to be damaged and we are not intending to do this to try to get damages on behalf of our dealers. That's not what this is about.
All I'm saying is that's how it's written. I mean, we could write that you are limited to some kind of injunctive relief, no monetary damages, no attorney's fees. And we could do that, but that's not what this bill is.
We could we'd be happy to clarify on damages. I think attorney's fees, if we would prevail, will certainly be something the association be entitled to. But it's the purpose of this is not to go in and collect damages on behalf of our members. That's not the reason that we're doing it. It is primarily adjunctive relief or declaratory judgment or whatever. And we can certainly work on the language to make that more clear. Absolutely.
Thank you.
Thank you.
Further questions from the committee? All right, thank you all very much. Thank you.
I need to go back and sign it.
All right, that'll conclude the testimony for the proponents of the bill. Now switch to the opposition panel, Mr. Taberzi and Mr. Kress and Fisher. And then we have some folks joining us virtually.
Mr. Chairman, members of the committee, I'm Paul Taberzi. I'm an attorney from Baltimore. I represent General Motors and have for many years. It's always an honor to be before this committee. And we strongly, with respect to the sponsor, oppose the bill. Makes no sense. And frankly, Senator James's line of questioning is part of what I was going to dwell on. But I won't read you my law review article, but I have worked on standing for many years. I chaired the Administrative Procedure Act. The leading cases on associational standing in Maryland, and that's what this is, actually come out of Montgomery County. One's called Sugarloaf, chair, vice chair. Senator Kelly may know that. It was environmental groups, very sympathetic, very good groups, trying to block the Dickerson waste to energy facility. And the now Supreme Court of Maryland said, no, we don't do associational standing in Maryland. Federal system does, but we just don't do it. You've got to have a neighbor, or someone with a more concrete interest. So Maryland has a longstanding tradition, and you could look at the Sugarloaf case. That's a great case. We don't do associational standing. We don't grant it. To my knowledge, nobody else has it. I could be wrong about that, but I'm not aware of anybody, and I've been involved in this topic for many, many, many years. They brought it to the APA Commission, which I chaired. So it's a very kind of a strange concept, no offense to my brothers, but to give associational standing to auto dealers, they're great people, but not to give it to Chesapeake Bay Foundation, Sierra Club, environmental groups, which the Maryland courts have ruled don't have it and won't get it. So if this bill were to pass, I don't really know what the courts would think of it, but it is clearly going against the grain of Maryland law. If you were ever going to touch this topic of associational standing, I heard Senator West say this about the prior bill, you ought to do a work group. You ought to talk about the broader topic of associational standing for everybody. Environmental groups, Chesapeake Bay Foundation, which I would submit are much more sympathetic. Senator James made my point about damages. It's really a weird provision to say a trade association can get damages, which is what the bill says. So bad bill. It's a topic that maybe you take on holistically, but not just for auto dealers. Happy to answer any questions after my brothers speak, and thanks for hearing from me.
Mr. Chairman, members of the committee, my name is Josh Fisher. I'm with the Alliance for Automotive Innovation. We are a trade association representing the auto manufacturers that the dealers apparently want to sue. We strongly oppose Senate Bill 968 as it really presents a solution in search of a problem. And as Paul said, will disrupt about 50 years of case law in the state on associational standing to provide one special litigant status to a motor vehicle dealer association that no other association in the state currently receives. Maryland law already allows associations can bring appropriate litigation when their involvement is necessary as an aggrieved party, but not where its individual members would serve as a more appropriate plaintiff. There's no reason why the existing law applicable to every trade association that exists in Maryland should be revised to add a specific exclusion just for a dealer association. The statute that would be amended by this bill already allows any person who suffers, quote, financial injury or other damages resulting from violations of its entire subtitle to, quote, recover damages and reasonable attorney's fees in any court of competent jurisdiction. Notably, the bill would also allow a dealer association to recover damages, as has been pointed out. We are certainly very much opposed to allowing multiple parties the option to recover the same damages. Therefore, we would request an unfavorable report. Thank you.
Good afternoon, Mr. Chairman, members of the committee, Mr. Vice Chair. I'm going to have some excellent testimony today and say my colleagues have covered everything. So me too. Thank you.
Excellent. All right, we'll hear from the virtual panelists and then we'll turn it over to the committee for questions. Margaret, go ahead. You unmuted yourself first, so there you go.
Good evening, Chair Smith and members of the committee. My name is Margaret Durkin, and I serve as the Mid-Atlantic Executive Director for TechNet, a technology trade association. Thank you for the opportunity for allowing us to speak today on Senate Bill 968. TechNet is vigilant against overbroad and harmful laws and regulations that have the potential to stifle innovation. For a variety of reasons, TechNet is opposed to Senate Bill 968 in its current form. This bill, as referenced by prior speakers, would shield plaintiffs by allowing damages to be brought by an association, but not truly revealing the identity of the person who is seeking damages. Furthermore, we are concerned that litigation will become prevalent due to this piece of legislation. I understand that in the other states listed, that litigation is minimal, but unfortunately, we are unable to take the word, and our members are unable to take the word of those on the other side of this issue, that will not be the case here in Maryland. Because of that potential threat of litigation, ultimately costs will go up for dealers, associations, and manufacturers, which will ultimately hit the consumer. For the reasons stated above, TechNet is opposed to this bill, and I'm happy to take any questions. Thank you.
Thank you very much. Mr. Grimaldi, welcome.
Thank you.
Good afternoon, Chairman Smith, Vice Chairman Waldstreicher, and members of the committee. My name is Chris Grimaldi. I'm the Regional Director of Public Policy for General Motors. I ask the committee for an unfavorable vote on this legislation. I believe there is much more to this legislation than simply an effort to reduce the annual slate of bills brought to the legislature by auto dealer interests. Rather, the intent of the Maryland Auto Dealers Association is to use standing to have the ability to substitute their judgment for that of automakers through litigation over policies that they may disagree with. Moreover, MADA could also seek to overturn automaker policies that may be based on compliance with state law and state mandates. For example, last year, Ford was sued by 6 separate dealer associations over a new policy that they instituted for dealers to sell and service electric vehicles. As you know, Maryland has adopted California regulations that are designed to promote the sale of electric vehicles and to phase out internal combustion engine vehicles. MADA has concerns with this regulation and supports legislation by Senator Hershey, SB 1063, which will eliminate the ability of the Department of the Environment to enforce this regulation. Assuming Senator Hershey's legislation fails and SB 968 is enacted into law, MADA could then sue the automakers alleging a violation of the state franchise law to obstruct or limit their ability to comply with the regulation. In this hypothetical, the court would have to adjudicate between a duly enacted franchise law and an environmental regulation promulgated by a state agency. In conclusion, I ask the committee for an unfavorable vote. Thank you.
Excellent. Thank you very much. All right, questions from the committee, Senator James.
Yes, and you all can get back to me, but one of the witnesses I think it was you, Mr. Taberzi. I'm trying to look myself really quickly, and I was going to ask the supporters of the bill, but I'll ask you all to get back to me. I'm not aware of this happening anywhere else in the state of Maryland. So I'd like that maybe confirmed. I know it's hard to confirm a negative. I know it's hard to confirm a negative.
I'm not aware of any, and the case law says you just can't do it. Now, whether
Yeah,
honestly, there could be something tucked in the code somewhere across the street. I think the proponents did make reference to some code provisions they may know, but nothing to my knowledge. And I'd be maybe there's something tucked away in a sort of a strange statutory thing, but the common law says no to association
And then
standing.
if you could just, because I cannot read Sugar Loaf on my phone fast enough, and it is, I think, 60 or 70 pages long. Could you just summarize why the court rejected this idea? So I never be here as a lawyer, and just a short explanation.
Well, they actually brought it to this commission that I chaired years ago. We revised the Administrative Procedure Act, and they asked us to get into it. We didn't get into it. We had Judge Eldridge on our commission, rest in peace. But people wanted to block the Dickerson Waste Energy Facility, which again, my friends from Montgomery County are familiar with. And the neighbors could do it. There was no question. But in addition to the neighbors, various groups wanted to come down. I don't know literally, but let's say Sierra Club, Chesapeake Bay Foundation, very good groups like that. And the Court of Appeals then, now the Supreme Court said, no, you have to be one of the people with a specific real interest. And there were plenty of them. They could block it or oppose it, but these trade associations, there's no privity. They don't have a specific injury. They can't do it. And that's been the longstanding law of Maryland on associational standing.
I think one of the reasons, if I can, because I've known this a long time, but I think it's that, especially in this context or any context in which a real plaintiff with a real injury could and is well protected by the law as it is and can go forward with the claim. Certainly an association can help defray the legal costs if they like, provide counsel if they like, can do all kinds of things to bring down any kind of, burden if someone thought that were the issue, or even bring in expertise. None of that is prohibited under current law. It's simply that you want a plaintiff who has an interest and a narrow interest in their own injury rather than perhaps broader policy implications. Isn't that so?
You've said it, Senator James. And again, no offense to my dealer friends. they're sort of the opposite. They're very well represented. They have good lawyers, great lobbyists.
Well, I meant just in
They don't
case.
need a cover group. They can come down and Jack Fitzgerald or anybody and file a claim or sue us, or it's a free country. They don't need it. And I frankly, no offense, some environmentals groups maybe need some help, but the Court of Appeals has always said no. So that's why this bill is really kind of an oddity to me, with respect.
Senator James, well, Mr. Terberzi's, what he expressed verbally is, I think, particularly well synthesized in Mr. Fisher's written testimony. So if the committee wants to look at that, look at the current like status of associational standing, I thought was well done in their testimony. Okay.
Thank you. Always an honor to be here. Thank you, Chair and Vice Chair.
All right. Thank you very much. I think that's it. We're missing Miss Durin is not here virtually. Is that right? Okay. All right. With that, that'll conclude the testimony in the hearing for Senate Bill 968. We'll now move on to Senator Folden with Senate. Which one do you want to take first? 1003 or? Okay. All right. 1003.
Good, sir. Mr. Chairman, esteemed colleagues, members of Judicial Proceedings, for the record, Senator William Folden representing Legislative District 4, Frederick County. Before you today is Senate Bill 1003. And this is actually a pretty simple, straightforward bill, and it'll probably be the fastest bill of the day. And I'm going to talk even faster, so you guys will be really happy. Simply put, this bill is a common sense measure to an antiquated process in vehicle law and vehicle allocation and deliveries. So I'm going to leave it at that. I would ask for your favorable report, and I will let these two fine gentlemen give you extra clarity.
Good evening. I'm Rob Smith with Fitzgerald Automall. It's a privilege to be here, Mr. Chairman, Mr. Vice Chair, and members of the committee. This law was originally written based on how we ordered stuff. It was kind of based on how liquor was ordered back in the day on paper. Today we do it electronically, and the work in the hearing that we had in the Senate, literally in the middle of the meeting, they decided that, hey, why don't we just change this, put an amendment? So we're asking for a favorable with the amendment of changing the word to adding the word electronic, and that's it. Thank you for hearing my testimony. Ask for a favorable report.
Thank you. I'm Franz Schneiderman, Consumer Auto. Again, yes, it's a simple bill to update the statute and make it consistent with the way this actually works now. The section of the code that governs the way cars get ordered still says that manufacturers have to respect orders for cars after, quote, receipt of a written order. It's not done that way anymore. They do it through electronic portals or just accepting an allocation. So this bill simply modernizes the language to say, submission of order or acceptance of an allocation, or even the even simpler version that the House amendment supports. So we hope this is pretty straightforward. Hope you'll support the bill. Thank you.
All right, questions from the committee? Seeing none. All right, thank you all very much. Am I missing anyone else? All right.
Thank you.
Thank you.
It's Mr. Kress. Did you want to, anyone else want to, and Mr. Fisher, go ahead. Yeah.
Thank you, Mr. Chair, Mr. Vice Chair, Josh Fisher again with the Alliance for Automotive Innovation. Submitted written testimony favorable with an amendment. The other side, we're all kind of circling around the same thing, clarifying that electronic order is acceptable. So if the bill is amended that way, we are favorable and appreciate your time.
Excellent. Okay, great. All right, with that, that'll end the hearing for Senate Bill 10.
Everybody's together.
We'll now move on to Senate Bill 1004.
Mr. Chairman, esteemed colleagues, members of the Judicial Proceedings Committee, for the record, Senator William Folden, Legislative District 4, Frederick County. The last bill you just saw had no fiscal note. This one's even better and going to be shorter. This next one is Senate Bill 1004, and this deals with the specialty tags being available for motor vehicles. And simply, in 2000, I believe, 2013, state of Maryland came out with a vintage registration tag that was yellow with black writing. It was only available for 1 year. I don't think a lot of people realized that it was only available for 1 year. They thought it was going to be available, and they now are no longer in production. This bill is so super sweet and simple. This bill will actually do something that never happens in our legislative body. It will create revenue by simply putting this in place and allowing these tags to be for sale again. And the MVA was established in 1906 when they had registration numbers that were issued to the vehicles, and the owners were responsible for putting their own vehicles on there. In 1910, they established a process of an actual tag to put on the vehicle that was distributed now at that point by the MVA, and ever since then. So this is a reflection or a snapshot back to 1910 and what those tags similarly looked like at that time, and allows us, for those vintage collectors that love these tags, to be able to still have them on their vehicle. And again, I would ask for, you can see the net benefit overall that each year would have. And with that, I would ask for your favorable report.
Thank you very much, Senator. Oh, Senator Kelly has a question.
Sorry, that's great, but hey, can you describe them again? They sound really cool.
Can we tab her?
So they look like, if you imagine the yellow tags, like on the state police vehicles, theirs are established from similar. They're yellow and they have black letters on them. And at the bottom, it says vintage 1910.
Check this out. This is so Senator Kramer was on the Eastern Shore a couple of years ago. He goes into an old trinket shop and finds these vintage Senate plates, and he gets them for the members that he could find them for the day. So he got one for him. He purchased Senate 20 in the vintage. I'll bring it. I would have known this because I'll bring it. I have it. Senator Kramer gave it to me.
Fascinating.
It's pretty cool.
Yeah. So it's a win-win. It brings back a little bit of our history and tradition, and it allows us to make a revenue, make monies again and move forward to have these on the roads. And I think it's perfect.
All right.
Move favorable.
Move favorable. There you go. I like it. It's a throwback. All right. All right. With that, that'll end the hearing for Senate Bill 1004. Thank you, Senator Folden. We'll now move on to the final bill of the day, Senate Bill 406. All right, thank you, Mr. Vice Chair. For the record, Senator Smith here to present Senate Bill 406. Now, if you look in the bill file, you'll notice there's a mountain of opposition. And so when I saw that this morning, I was like, I'm calling my bill last. I'm making these guys wait all day for that. You bring that much opposition, Chair's bill, you're going to go last for the day. So no, so I'm going to ask you a few. I know we usually have questions of the sponsor, but I'm going to ask you all a couple questions first before we start this presentation. Senator Folden cannot participate because he will know the answers. He will know the answers to these questions. All right. So if you're driving along a 4-lane highway or road, and there's a bus stop, with children that comes out, the stop sign comes out, the lights start flashing. What do you do if you are on the other side, all the way over 4 or 5 lanes over? Are you required to stop?
Yes, you are. Is there a median in between?
These are good questions.
Right?
Wait, does it matter if there's a median?
If there's a median, don't. If there isn't, then you do. And I know this because my stepson got that really expensive ticket.
Oh, there you go. So you're proving. So there. Is that a difference? Is that a difference? So hold on. That is the difference. That is so Senator Kelly's the most, she's good. So these two, I wish you almost didn't answer that question because that was very good. That was good, but you got smashed with the fine. And so you understand. But yes, I did not know that, the answer to that question. So, and it does matter if there's a median. So if there's a median, you don't have to stop. If there isn't, then you do. So if it's 4 lanes, 5 lanes, 6 lanes, okay, 4 lanes is generally the problem here because in our county, at least, there are a lot of these situations where there are 4 lanes, and in some places there are 5 lanes. And what's happening is that folks are going down the opposite direction and getting tagged with these super expensive tickets because there's no median, and you actually are required to stop. Now, that's obviously that's for safety. We want all of our students to be safe when they're getting off from school and going home or going about their day. And so I remember last year we had this cross-file, the majority leader of the House, my seatmate David Moon had this bill, and they played some videos. And I think they may have the videos here today queued up, but if not, they're going to describe them. And they're accurate. I mean, I think it's something to be very concerned about because we all care about, or I have a 5-year-old and she takes the bus occasionally. So I'm very keen on this. But what's happening is that it's a super expensive ticket. And as Senator Foldy, you may know the answer to this question. It's a little bit more difficult. So what's the fine? What's the maximum fine for this? It's $1,000. $1,000. But if you prepay, it's $570. At least that's what the fiscal note says. So it's $570. And you can get 3 points assessed against the individual's driver's license. So if you're on that 5th lane over and you do this, you're going to get tagged with.
Points assessed by a camera.
It says a person convicted of a violation of either of these requirements is subject to a fine of up to $1,000. The prepay penalty for either violation is $570. So and you've got to be, how many feet away do you have to be? Even if you're 4 lanes over, how many feet away do you have to be? 20 feet away, 20 feet before or behind. So that's what the statute says. So yeah, and I've got the statute. It's the Maryland Transportation Code 21-706. And so yeah, a person convicted of a violation of this subsection is fined not exceeding $1,000. Prepay $570. Anyway, so what the bill does, so anyway, in my district, I've heard a lot about this. So why the original sponsor of this bill brought this forward is because more than 70% of the tickets for fiscal year 22 were coming from people on that opposite side. So on the 4th lane over. And so where there's no median, because we need to do better with education, but 70% of those fines are coming from that people that are going the opposite direction on the opposite side. So that's the reason and the impetus for the bill. And so what the bill does very simply is that it says that the offense has to occur on an undivided highway with 4 or more lanes. The driver has to be traveling on the opposite direction as the school bus. So opposite way, 4 lanes over. And it requires then also a study. SHA has to study the high incidents where these tickets are being issued and develop and promulgate some specifications for increased safety, for pedestrian safety for these students and for bus stops. Now, there are a couple of actual options being pursued here in the House, although we only have one vehicle or legislative vehicle that we're discussing here today. So one is that this bill makes it the first violation a warning. Okay, that's what this one does. Then there are 2 other vehicles in the House which are currently being considered by the Environment and Transportation Committee. One is to move the bus stops on undivided highways, so move them to more safe locations. And then third is to take money generated from the stops in Montgomery County only and pull them to fund pedestrian safety elements for bus stops. So those are the 3 options that are being considered. This is the option here before you today. I thought it was an interesting subject. Obviously, you'll hear a mountain of opposition behind me. And I think, pay attention to what they're saying. We all want, obviously, pedestrian safety for our students. But the fact that 70% of these tickets are being slammed for folks that are on the opposite side of the road. There's another part of the study, and I have some citations here for the bill file, that in my district in particular, a lot of these are happening in lower income areas. And so the fact that you're getting this hefty fine for a first-time infraction on the 4th lane over is particularly debilitating for some of the folks that are struggling to make ends meet. So with that, Mr. Vice Chair, members of the committee, I'll take questions, but I'd ask the committee for a favorable committee report.
Questions from the Senator James, did you have a question?
So if you're, because I don't have this in Harper County. So if you're in the 4th or 5th lane over, coming in the opposite direction, I don't know about, does this cause not just backups, I mean like people screeching and braking? Because I can imagine if they're going, what's kind of like a dual highway, isn't it? And there's bus stopping over here, and then there's cars over here. I am just curious as to whether in the studies that people are doing, what kind of other issues are being created by these lanes of traffic that may not even catch this bus in the, off to the side. Is that being sort of looked at, what the traffic is around these incidences and what it does to have the drivers breaking that far over and stopping?
No, I'm not
know.
I don't know
I don't
if it's
know.
called the traffic study. The folks that come, SHA, what are they called? Those folks that come and do those traffic studies,
Yeah.
there's a particular designation for
Yeah, I
that
thought
profession,
that was
but
called traffic
I don't know the answer to that question.
Yeah.
It is interesting that, I mean, the only difference is if it has a median, right? So if there's a median, then there's, I guess, a place for coming like a safety island for the kid to
Well, that's the,
stop.
my
and
other
then-
question was, I can't believe this would be allowable, but for a bus to stop on one side of a 4 or 5 lane highway, and
Yeah.
it would be okay that the bus stops here, but the child is supposed to get out, cross in front of the bus, cross perhaps in front of another lane that's going parallel to the, and then being asked to cross 2 or 3 lanes in opposite direction, which just to me is probably the real problem here
No, I
of
suspect you-
allowing bus stops to be in under those traffic conditions. Is that what you're hearing?
I'm 100% confident that you were going to hear that type of analysis from the panel behind me.
Right.
And I think that's not a statutory requirement, but a regulatory thing that says, hey, like when practicable, they'll expound upon this, but that it has to be on the side where the school stop has to be on the side where the housing is or where the home is.
Right,
That's where the supposed to be the locations. But that doesn't prevent, and then, I'm making an argument against this bill, but that doesn't prevent students from traveling across
True.
to
That's true.
McDonald's or, a friend's house or whatever else they're doing. So
Thank you.
I think that's an option for another bill that's
Yeah.
considered an ENT.
Okay.
Thank you, Mr. Vice Chair.
Thank you. Senator Kelly, was your light on? Can I ask a quick hypo, Mr. Chairman?
Yep.
So there are highways. So first of all, I have 3 children like you that I care deeply about their safety. My kids go to public schools and they ride the school bus. So, but there are 4-lane highways with quasi medians in the middle. So these are turn lanes, or there are partial medians, but not a continuous median that people treat like a median, but may not be technically defined as a median. So under current law, where these quasi medians exist, are people still eligible to receive tickets when they perceive there to be a median right there?
So here's the stat. I'm going to read you the language from the statute. It says the section does not apply to a driver of a vehicle on a divided highway if the school vehicle is on a different roadway. So I don't know is the answer to the question, and that there's definite ambiguity there. Maybe Senator Fulton knows, but
Well, I'm sorry to lead the witness. Your district and mine both have Georgia
a lot of
Avenue,
that. Yeah.
which has a 5th lane turn lane that is treated as a median because it's not a travel lane. But
You may know.
it's not a median for purposes of our law. And so people are getting ticketed on the far side of
Georgia
places
Avenue,
like
yeah.
Georgia Avenue and other major state highways that don't have a full median between, but have what people perceive as a median because it's not a travel lane. And I think
Yeah.
that's one of the big issues that we see here.
That's right.
So, Senator Kelly.
Thank you. I would just follow up with an isn't that so question to say that when my beloved stepson brought one of these very expensive tickets home, we went to go look at the road to see if it was divided because I was sure it would be. And in fact, it was, except for like maybe a 10-foot gap where there was no median, which is where the bus stop was located. Isn't that so?
Wow. Clever. All right.
Lots of anecdotes here. Senator Fulton.
So I appreciate the opportunity to speak. And I would like it to be noted that I did 2 bills before the single member proponent panel of this bill was finished in the same less time. Mr. Chairman, there's no quasi medians that are either medians or they're not, and they're like easily identifiable by either vegetation or an elevated curb or a Jersey wall. A turn lane, a bidirectional turn lane is still a lane of travel. And then when there's a collision, it's still an identified lane within the transportation article. So I just want to point that out, that I'm not saying it's right, because I have always questioned the wisdom when you have, 4 or 6 lanes wide, and the person in the far, in each of these lanes are like 12 to however many feet wide, depending on the speed of the road. it's a pretty far stretch. But these are identifiable lane roadways, and unless it is an elevation difference or a terrain difference, it is a part of the actual continuance of the roadway. Isn't that so? Thank you.
I appreciate that. All right.
Seeing no further questions, we'll move to the opponents. Mr. Willems, Mr. Rodriguez, Ms. Sample, Mr. Wolf.
All right, hello, thank you to the chair. Thank you to the members of the committee for having me. Again, my name is Sarah Sample here on behalf of the Maryland Association of Counties, and we are here in opposition to this bill. I think we could probably all agree that it's not ideal to have a school bus stop on a highway. But when it comes to these particular instances, the state does set the penalty and counties are authorized to enforce it. And what we have found is that when they are sending these citations, we are seeing a very, very low recidivism rate. And we just think that taking that compliance tool away is unwise in these situations that are deemed to be so unsafe that the penalties are what you've already heard. This bill, as you heard the senator say, this is a statewide one that would mandate a shift for all jurisdictions. And this is a very narrow problem that is happening in a few jurisdictions. So we think considering something that's a little bit more specific to where the problems are actually happening might be a better strategy for this. But for these reasons, we oppose this bill. Thank you.
Mr. Chairman, Mr. Vice Chairman, members of the committee, John Willems, representing the Maryland Association of Boards of Education, here today to testify in opposition to Senate Bill 406. Look, we take student safety very seriously. And, Mr. Chairman, members of your delegation, why not just say Delegate Jared Solomon, draws our attention on a regular basis to the need for sidewalks, safe routes to schools, and investments by county governments and school systems to ensure the safety of students in terms of getting to and from the school buses and getting to and from school when buses are not provided. We are very concerned on behalf of all 24 school systems with the lack of public education around the need for vehicles to stop for school buses with their lights on, with the stop sign out, with the lights flashing when students are either boarding or leaving the school bus when on a road without a median, right? And so, this handy dandy little tiny flyer, this is a Howard County flyer. Consider the cost. School buses in Howard County are outfitted with external cameras to ensure student safety. Drivers traveling in both directions must stop for school buses except when across a divided highway. I personally think that when I get off of the Beltway onto New Hampshire Avenue to visit my friends in Tacoma Park, I should probably see a big sign that reminds me that I am on a road without a median and you have to stop for a school bus with its lights on and its stop sign out. When traveling in either direction. More public awareness, more public education, but not less enforcement and not a warning the first time someone blows by a school bus, even when going in the opposite direction the bus is on a 4-lane or more road. Again, student safety is paramount. Thank you.
Good evening. Thanks for having me back again. I've testified obviously several times on both sides on this. So to Senator Smith and honorable members of the Proceedings Committee, I want to thank you for allowing me to come again. Thank you for allowing me the time to speak on this legislation again. The Anne Arundel County Police Department stands in opposition to Senate Bill 406 as written. The current law that we talked about earlier, Transportation Article 21706.1, already permits a jurisdiction to issue a civil citation or a warning. The jurisdiction can issue a warning if they choose to. So to be clear, our firm opposition to this law is in order to maintain the safety of our children. As previously stated during our opposition to similar legislation during last year's session, our children don't know the difference between a 4 or 5-lane highway without a median. One child lost to a motorist who fails to stop and obey the law strikes a child is absolutely unacceptable. Since the inception of the automated bus camera program, we have seen several video examples from right here in Maryland of children being struck in the exact situation that this law is trying to mandate first-time warnings for. The law is clearly defined in the transportation article. It's explained in the MVA handbook, which is used for driver's testing, and it's all taught in driver's education classes. We reiterate, this is a very serious traffic violation. So in conclusion, there are many other issues that have been brought up that are associated with this legislation that do warrant further discussion, such as changing bus stop locations, better education, roadway changes, physical medians, transparency of the automated enforcement data, and law enforcement jurisdictions are already having these conversations with our stakeholders. There is nothing in this legislation that would permit a citation if an egregious violation was observed on video. So one thing remains clear, requiring warnings in these situations would be detrimental towards the goal of modifying behavior, and such we are in opposition to this bill as written. And I'll take any questions as far as how the program is actually run and mandated, because sometimes there's some misunderstandings about how the tickets are actually issued.
Good evening, Mr. Chair, Vice Chair, members of the committee. My name is Donnie Wolf, and I'm here representing Bus Patrol in opposition of this bill. Bus Patrol is one of the providers that services a number of the communities in the state of Maryland. We service Anne Arundel, Carroll, Cecil, Charles, Howard, Montgomery, Prince George's, Queen Anne's, and Somerset. Our mission is to make the ride to and from school safer for all children. But we do have some concerns with this legislation. Although we are simply the provider of the safety services, we wanted to stand in opposition with the folks here. I want to be clear that we are certain that in your heart, Mr. Chair, and in the heart of House Majority Leader Moon, that it's in the right place. And I recognize that this is a difficult issue to navigate. As an alternative to the warning mandate in this bill, there are other solutions which have been proven to make the road safer for children. Traffic calming devices, crossing guards, potentially even moving some of these bus stops that are inherently dangerous. You know, in fact, that's uniquely what Bus Patrol does. Is we operate a program where we operate a program in partnership with the community, and we install and monitor an upwards of over 1,000 school buses. And we provide the community with this violation data. Communities then can take that data and really use it to make data-driven decisions regarding route planning, school bus safety. We encourage it. With that, thank you, Mr. Chair, for your attention on enhancing the safety. We hope we can continue to collaborate with you and Majority Leader Moon and making this trip, safer for kids and for drivers on the road. Thank you.
Never.
I would love to just ask you a question, because as a law enforcement officer, I am shocked. I'm from Harford County. I don't think we have any of these particular situations that I'm aware of. I don't think so, even on Route 40, but sir, I don't even understand why you should allow a bus stop in this situation at all, with or without a median. But I did want to ask you, a median doesn't mean a place a child could stop. Sometimes aren't they just pretty narrow? And I mean, they're not for you to loiter on or hang out on, right? These medians don't, by design or law or statute, have to be a place you can safely stand for a while, or do they? Maybe I don't know that.
I guess the core of your question sounds like with the locations of bus stops, there's a lot of parameters that go into that.
Yeah.
We've discussed at several of these hearings that it's not easy to move a bus stop, but also we should not keep a bus stop at a location that is inherently unsafe. If 10,000 citations are being issued at a location, why are we not talking about moving that?
Right.
And I can't answer that question for every jurisdiction in Maryland. I can answer it for Anne Arundel County, because we've only had the program for 2 years, and we were very mindful of analyzing the locations. And to be honest with you, we have no locations that are even close to 1,000 citations. And we have the regular meetings with our transportation from school board and other stakeholders to discuss what can we do. So the location of that 4 or 5 lane roadway, like you said, that there's so many different parameters of where these bus stops are, and I think the senator said it earlier, we can't control what a child is going to do. That's the thing is we have video where kids were nearly hit in Anne Arundel County where they got off the bus, should not have crossed into those 4th or 5th lanes, but they're doing what kids do and they're roaming across the street and they've nearly been struck by cars that didn't stop for the bus. So it's very difficult to just say, hey, let's just issue warnings in these cases. The technicians have that authority to not issue a citation. If they see the things that we're talking about, that it wasn't clear, they're under no obligation under the law to issue.
I guess I was gonna say that I know it would devastate a driver, but most drivers to ever hurt a child, right? But you are to me, just it's inherently unacceptable risk to ever have a school bus along these roadways. I mean, I'm not, part of me as a mother would like to pass a law that says you just can't do it. I'm not gonna go there, but I'm just very surprised. And I think you're saying, you generally think that these are pretty inherently dangerous with or without a median, right?
Yes, I would agree that the locations, some of them that have been described in these hearings are dangerous. And we even have several in Anne Arundel County. I'll use the example of Riva Road. There is only so many places they can put the bus stop on Riva Road in the Annapolis area. Those are our high impact locations where we get several hundred citations. So we are looking at ways we can do calming, ways we can put signage up, and possibilities of moving those bus stops. Those conversations are happening, and we're only 2 years into our program. So I do agree that that is an area, all those areas that like bus stop locations and data and transparency with that data.
Right.
Those are all things that the main issue that we're in opposition for, I know, as law enforcement, is the requirement to issue a warning, because that is already in law. Any jurisdiction can issue a warning or not issue a citation. If you force us to do that, it's inherently dangerous. It's not going to change behavior. And there is no mechanism to even do that. We would have no way to do that within the existing system. So we would have to figure that out, but there's really no way.
I just felt I had the benefit of your knowledge on the other issue, not on the bill itself, but these inherently dangerous bus stops. I really thank you for helping me understand that they are in fact inherently dangerous. Thank you.
Thanks. Actually, one last question, just because building off of what Senator James said, and Captain, you alluded to this, but you said in your jurisdiction, really not a high number of these citations are issued in one location or another. And so, as in like an exorbitant amount, like high.
No, and we post on the website, and I believe most jurisdictions do that. I can't speak for all of them. The data from each year.
Yeah.
And in our annual report, it has the locations that had the most citations. And to your point, probably half of the top 15 locations were in that situation.
Got it.
So I will agree. It is an educational component of this. Even though you get it in driver's ed and you get it, in your handbook, most people don't even know. They don't realize that you have to.
And if the median is like some semblance, is some level of protection, maybe not, maybe. But let me take this. So 9 of the 10 of the stops with the most violations in my county were without the medium. So we're just the clear 4 lanes over. But you mentioned 1,000. So I'm going to tell you something. Like 4 of the stops in our area issued over 1,000 citations.
Right.
And so
we don't have anything in Anne Arundel County.
Yeah, one of the biggest ones was on River Road, I think, in your district, and which is 1,800 citations in FY22. So these are high, these are dangerous, right? If that's an indicator, or at least an indicator of how dangerous it is. So my question then is for Mr. Woolens. One of 2 things are going to happen this session. Either we're going to do a first citation as a warning, or we're going to tinker around with the school boards and we're going to make them move those locations. Which one do you choose?
I would not prescribe that a school system move a bus stop based on the regulatory criteria that those bus stops have to be reviewed and approved by state police and local law enforcement, standards adopted by the State Highway Administration and the school system. We
push back or reject the notion that we have inherently dangerous bus stops. And out of the concern that while it may seem dangerous to have a bus stop on a busy road, the rules are that those students are not residing on the other side of that busy road, and that the alternative to move that bus stop into the neighborhood is potentially more dangerous, in that you're moving the bus stop onto a street with cars that may be parked on either side, streets without sidewalks, and neighborhoods that may be oriented in such a way that the bus may have to back up to turn around to return to the major
Those are
thoroughfare.
regulations. We're looking to pass a statute. So which one do you choose?
I would choose perhaps changing the prohibition on or the requirement to issue a warning to leaving that discretionary to local law enforcement.
Finding a third way there. All right,
Yes.
all right. Because that's the Nikki Haley answer right there. All right.
Okay.
I appreciate it. All right. Thank you very much.
Thank you.
All right. Senator West.
I'm sorry.
So I came to this party late. Mr. Bullens, maybe you could answer my question. And I think you need to stand up at the podium in order to get a good answer. So why do we have school buses stopping on busy 4-lane highways? Have we already had this?
Yeah.
Okay.
Yeah.
What?
On the same page.
Let me just finish. If you've answered the question, I'll look at it on the video. Why do we have school bus stops on busy highways in situations in which kids are going to have to cross a 4-lane highway? Can't we have the bus stop on one side and then go up and make a U-turn and come back on the other side of the road?
Sir, that is precisely the rule as you just described it. We are prohibited from having a bus stop on a busy road intended to pick up students who live on the other side of that busy road. Those buses do turn around and pick up students on both sides of that busy road.
Well, if that's the case, then, and the bus is stopped on the northbound side of the road to let kids off who are not going to be crossing the road. They're going to be going into the neighborhood adjacent to the bus stop. Why do we want to make cars stop on the far side of the road? They're going the opposite direction.
It is because there is no median. So there is no barrier, there is no grass, there is no cement, there is no physical barrier between those north and south, east and westbound lanes whatsoever. And kids are kids. We've had kids with their earbuds in, step off the bus.
Well, wait a minute, but they live on the side of the road where the
moves.
bus is stopping. Why would they cross the road? All right.
The adolescent brain.
I hear you. So that like there's a 7-Eleven over there and the kid wants to go get a Slurpee or something.
But if I could, the standards do include that the bus stops be located if possible to maximize the visibility of the stop school bus for approaching traffic. And there are other criteria. So that visibility, like it or not, that stopping on the busy road may be a very visible place for that bus to stop. That may be where the sidewalk is. And that may be a very reasonable and prudent place to put a bus stop as opposed to pulling that bus.
Let me
into
stop
the
you. I don't want to plow old ground because as I say, I was late to this party, but thanks very much.
Just don't cross 4 lanes of traffic. Okay. All right. Captain,
Senator Smith,
the last word of the day, Captain. Go
Yeah,
ahead.
just to answer your question, because you had asked like about the locations, you said in Montgomery County, River Road, 1,000 to, our data is posted and it's transparent on the website. Our highest location in Anne Arundel County was 552 on River Road. And the 15th location, 147. So we're dealing with such a different number of violations because we do analyze this and look at these locations. And that's what I'm saying. There's so many other issues that I think that it's different from jurisdiction to jurisdiction. We have no location that is anywhere close to 1,000 citations being issued at a bus. Probably for a variety.
Maybe we make this a Montgomery County. We talk to our Montgomery County School Board friends and see how they feel about this whole thing. All right. All right. I love you, Mr. Williams. That's right. It's your hard time. Thanks, though. Thank you very much. Thank you all. Thank you.
Thank you.
All right.
Thank you.
All right. Yeah, with that, that was awesome. You hear the voice of God, drop that gavel. All right, that ends the